discuss.
Mr. Perry?
Thank you, Judge. Judge, I don't see that anything of substance or any significance has changed since Rodney was offered the reduction in charge to a felony 4. Again, as we explained in chambers, Rodney was forewarned, no more contact. He saw a Facebook post, and it was from DeWimba. It said something along the lines, "I still love you," and again, hoping against hope. I'm sorry. Okay, it was actually a video, but he responded to what he saw that was a new post, not an old post. Probably 3 or 4 words trying to tell her that he still loved her. Yes, it was a violation. It was not meant to be harassing or evil. It was simply to convey a message. And so that I don't think is a significant change from the reduction to the felony 4. And thank you, Judge, for allowing me to read those 5 pages. And quite frankly, in those 5 pages, what I see is a man truly struggling in a relationship where he has genuine feelings for his wife and a belief that a commitment of marriage is a life commitment, even though there is turmoil and struggle in that relationship. I don't see a man who's putting all the blame on his wife for his demise. In fact, I'd like to read just a paragraph or so out of his statement to the court. He says here, and this is the last page of his 5-page handwritten, fairly dense letter to the court. "Therefore, I have filed for divorce because I now see by loving her," meaning DeWimba, "I have destroyed my life. I pray that someday we can have a sweet marriage, but I see that even though it may hurt, I've got to keep my distance until she is able to control her episodes," spells, like breakdowns. "I'm sure I have to take responsibility for my actions and sometimes poor judgment. I'm trying to love and keep our love, but I clearly now see I am not trained or equipped for the well-being of herself. Even though I want and have tried with love and persistence or long loving for her, I still love her, but need to stay away." So, Judge, again, I don't think that there's any, he's accepted responsibility. He's entered his plea of guilty to the F4. He acknowledges that there are things about this relationship that he does not know how to deal with, and he does not handle them very well. He does have a life experience of law-abiding citizenship. He was married for 38 years before that wife passed. Never did they have these types of struggles. Never was he ever charged with domestic violence. He owned and operated a business here locally in Lebanon. It's a pallet refurbishing and renewal business. It's his family business. He was the sole operator, but he from time to time had part-time employees helping him, part-time and full-time. But my point, Judge, is he got into this relationship purely out of his love for DeWimba, but there were things about the relationship that he had never experienced. I believe that there were mental health issues that he did not understand, and there were constant struggles that he did not know how to handle and did not know where to go for help. I believe that if the relationship is over and if Rodney can walk away, the court will never see him. I think he'll do very well on probation. He is responsive. He follows directions normally. If he understands what is required of him, he will follow through all the way. He's shown he's got a life of doing just that. Judge, we're not in favor of a prison sentence, obviously. I believe that Rodney would do very well on community control, whether it includes anger management or batter's intervention or even therapy to help him understand where this relationship went off the rails. I know he would like to address the court, but would ask the court for a sentence of community control. I understand that DeWimba sounds like she still has feelings for him. Rodney just said he has feelings for her, but they both realize they're better alone than they are together. So I do think that a no contact order would be appropriate. I will say this also, Rodney does have a home here in Lebanon. About 9 houses down from his home is DeWinva's father's home. My understanding was that she was living there. It sounded like to me that she said she might be homeless soon. I don't understand that. That's my greatest concern, but Rodney also has a mother that lives in Lebanon, and she lives about probably 10 or 15 minutes from his home. I do think there are arrangements that can be made to ensure that they not have any contact with each other, but I do think he will succeed. I think he recognizes this relationship is over. Dave Ernst represents him. There is a divorce that's been filed. I think there's a trial in March. He knows and understands that that is the best, not only for him, but also for DeWinva, who will soon be his ex-wife.
Thank you, Mr. Perry. Mr. Long, anything you want to say?
Your Honor, all I can say is I thought love would overcome all these battles. To me, marriage is more than a piece of paper. It's a covenant. When I married my wife, I didn't love her. Still love her. But I know I gotta get away. Stay away from it. I'm not equipped for this. I thought love would change it, but it's not. I've done the best I know how to do. I don't have a problem staying away.
Thank you. I do have a question, and I don't care who answers it. Back on November the 8th, the court was notified of this contact. Was the contact a phone call, or was the contact a response on a Facebook post? What was the contact? I'm sorry?
Messenger.
Facebook Messenger. Is that right?
Facebook Messenger.
There was no phone call because it was originally reported, it was originally reported by you to court services that he called you.
He did. He called me on my number.
Well, they checked his phone and there were no outgoing calls to you.
He erased. Upset.
Do we know whether or not those records, those phone records were supposed to be obtained for the court?
Yeah.
Has anybody got the phone records? We can show whether or not a phone call was made?
I know.
All right, the court's considered the statements made here today, the pre-sentence investigation, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. The court does find that the defendant is amenable to community control. So I'm going to place you, Mr. Long, to community control for a period of 3 years. You'll be subject to the supervision of the Warren County Probation Department. You're ordered to refrain from use of any illegal drugs, alcohol, or marijuana. Do you understand?
No problem.
You're ordered to successfully complete anger management. You're ordered to complete the thinking for a change course. You are to have no contact with Ms. Long. Now, when I say no contact, I mean no contact. I mean if she reaches out to you and she calls you and you answer the phone, that's contact. You have violated my order. You understand me?
I do.
If you see she posts something on Facebook and you click the like button, that's contact. You understand me?
I do.
If you send her a message through Messenger, text, or you send a message to her through somebody else, that's a violation of my order. Do you understand me? So there's a protection order in place, which means that a new charge will be filed. But I'm telling you that if I find out that you have contacted her in any way, in any form whatsoever, you are going to prison for 18 months. Do we understand each other? So do you understand?
I said yes.
Okay, there's nothing else that's going to come out of your mouth, because I'm telling you right now, if I find out that you've had any contact with her, I am sending you to prison. Do you understand me? That's the only way that I'm going to give her peace of mind. It's either you understand or you do not. You will follow my orders or you will not. That's as simple as that. All I want to hear is, yes, Your Honor, I will follow your orders.
Yes, Your Honor, I will follow your orders. There's no doubt.
You'll be released on electronically monitored house arrest, and you will remain on house arrest at the PO's discretion, on monitor at the PO's discretion. Now, you're also subject to a discretionary period of post-release control, which means that if you are sent to prison on this upon your release, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, You can be returned to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. The court does find that you have the ability to pay the costs of prosecution. If you don't pay those, the court can order you to do community service of up to 40 hours per month until you're paid in full, or an appropriate arrangement is made for payment of those costs. You do have a right to appeal the court's decision if you're sentenced to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Ms. Tranter, is there anything else?
No, sir, thank you.
Mr. Perry.
2 issues, Judge, very briefly. Rodney's very literal. He's worried that there's going to be a divorce hearing and he's not going to be allowed to go because of the no contact order. I will explain to him it doesn't include court proceedings.
As long as you are in this building with your attorney, that would not be a violation. But you will, any conversations with her will be through your attorney and your divorce attorney, not Mr. Perry, obviously, because he doesn't do divorces, right? Okay.
Correct.
Second question.
Second issue, again, he's having another flare up on his foot and his toes. He's going to see his podiatrist. There may very well be surgeries that require him to take medications. I just want to bring that to the court's attention.
I was aware of that. If the court actually had granted a furlough on
I
this,
understand, yes.
it was Lebanon Municipal that denied it. So
You can adjust with the monitor
Yeah.
for any type of medical procedure.
just
Very
talk with your communication with your probation officer is important. If you have contact from Ms. Long, you do not respond to it. You just alert your probation officer. You need to keep them informed. The monitor is as much for her protection as it is for yours. So if she says that you've been around her, we're going to be able to verify exactly where you are when. So anything else, Mr. Perry?
No, thank you, Judge.
All right, that's all. Keely,
Yes,
your client did not show up.
he is not shown up. I don't.
I almost said no seeing. Court does call the case of the people versus April Fleming.
Ashley Feltus for the people. Good evening. This is Public Defender Lauren Perry on behalf of Ms. Fleming. Say your name for the record, please.
April Fleming.
All right. Well, thank you for coming down. Ms. Fleming, I'm going to ask you again.
I did. I was.
You did what?
I huffed.
You were huffing. Yeah.
I'm sorry. I made a mistake.
Why weren't you? Why were you lying to me when?
I panicked. I just panicked. And I'm so sorry. I'm really, really sorry.
Ma'am, how frequently are you doing this?
Um,
I mean, are you doing that every day?
sometimes.
I mean, you're going to end up dying.
Can you give me
I
another
mean,
chance today, please?
Is that what you're trying to do? Are
No,
you trying to kill yourself?
no, I'm sorry. I just,
Okay, so, but how long have you been doing this?
I don't know. I've tried it off and on for a year or so.
Have you thought that you might need to get into some type of treatment or something? Have you?
I need to.
But you haven't done that.
I guess I haven't had anything like this happen. I plan on getting in touch with,
Who are you gonna get into? You don't even know.
huh?
You don't even know who you're gonna get in touch with.
Well, I know I have to speak to,
Well, I will say Miss Fleming does go to therapy at Huron Valley Consultants.
yeah,
As I've stated, we've been working on getting those medical records. I have reviewed some of those medical records. It indicates they do talk, and Miss Fleming's on methadone. We're still in the methadone program. So I do know, I will say that there are entries that they've had these types of conversations about her past use. So I think it's something that Miss Fleming knows that she deals with.
Yeah.
Have you told them that you're huffing?
No,
You haven't.
I know I have to. I
Sure.
plan on speaking to my counselor today.
When's the next time you see your therapist?
I can see him tomorrow morning.
Okay, so Miss Fleming, here's what you gotta understand. For me, when you tell me that you have an appointment, when you tell me all these things, it becomes hard for me to believe whether or not you're telling me the truth.
I understand that.
And that's because I asked you a series of times when you were on Zoom.
I freaked out. I should have said the exact truth. And I'm so sorry, Judge Simpson. Please give me a chance today, please.
Well, Miss Feltus, you want to say something?
I do, Your Honor. Ms. APA Cook was able to review the YouTube footage, and we shared with Ms. Kearney a screenshot that did show the defendant with the canister in her hand. I recognize that canister to be what I commonly refer to as dust off or computer cleaner, a type of compressed air. I'm very familiar with this drug, and I know that any time that you use it, it can cause instant death.
Yep.
This is a drug that is extremely dangerous, and the way that this is being ingested can lead to long-term issues as well as immediate death. The brain can die every time you do this. I think it's clear the defendant's very scared. I think it's clear that she wants to change. She wants to stop using. I really want to see her again. I'm very worried that we're not going to see her again. I truly, truly want the court to hear that this coming in from a place of compassion and concern, not a place of bond violation. This coming from a place for the people of actual concern. We will not see her. I am requesting that the court consider bond change with a release to treatment for her to get some help. But I do know that my experience with this drug and all the education I have surrounding drugs in general leads me to believe this is an extremely risky behavior. I ask the court to consider a bond change.
Please, Your Honor, please.
Sure.
I do know Miss Fleming does have a medical team around her. She sees her primary care doctor consistently. As I stated, she is in therapy. I think everyone's concern for Miss Fleming is warranted, especially the circumstances that this arose out of. I'm happy to work with her and get information to the people in the court if the court allows her to stay out of custody. Obviously, if she's in custody, that will take place too. I'm just asking that the court consider letting us work on that while she's out of custody.
Please.
She does have some medical issues that, and that's partially why she sees her doctor so consistently. This is an old retail fraud. I do, it's this case, I don't believe has anything to do with her use or anything like that. I just asked for
Well,
a chance.
might though, because if she's been using for off and on, as she's indicated, a year, this offense is in June of this year.
Well, I mean, I don't know exactly how long I've been using it. It's been for some months now. I don't know if it's been a year exactly.
Okay, Ms. Fleming, here's how I know you're an addict. You tell me one thing. And then when all of a sudden that doesn't seem like that goes your way, you change your story. You did that in rather rapid shot fashion when you were on Zoom.
I'm so sorry.
No, Miss Fleming, sometimes things happen for a reason, and not all of them we like what happens, but they happen for a reason. And maybe it also goes to what Ms. Feltes said.
Please keep me out of custody today. Please, Judge Simpson, please. I'm begging you.
You can't stop.
I am stopping. I'm done. I promise. I
And
promise
here's
with
my
everything
problem,
in
Miss
me.
Fleming. Miss Fleming, here's my problem. You've already lied to me today, repeatedly. Repeatedly.
I am so sorry. I am so sorry. I got here as soon as you said, please to come down. I got right on the bus and I
Well,
came
it
here.
was either going to be, and I think you understood, if you didn't come now, we were going to come and get you because there was going to be a bench warrant.
Okay. I think you're scaring me straight.
No, I don't think I have. Certainly not yet. But I'm going to let you know, if you think for 1 minute that I'm going to sit here when I know what I know at this point and have you die on my watch, and I haven't used what tools I have to try to make sure that you stay alive, you're sadly mistaken.
Please don't take me in today, Judge Simpson. Please, I'm begging you, please, please, everything in me, please. Please give me one more chance, please. Please, Judge Simpson.
And I will add, General, Ms. Fleming was honest with me when I spoke with her. I think she understands the reality of the situation.
Anything else you want to tell me?
Just that I'm going to tell you the truth from here on out. I swear on everything in me. I swear on everything in me, Judge Simpson. I swear on everything in me. And I voted for you.
You went about the 65 other thousand, but thank you, I guess. You're not dying on my watch, not tonight.
I'm not going to die tonight,
Done.
please.
I'm done listening. Listen to me now.
Okay.
You're not going to die on my watch. I can't trust you. I don't know what therapeutic routine you have, what you have surrounding you that I can safely let you out. Because whatever you're doing at this point, you do it, you go home and you're huffing.
I won't,
Yeah, I know. You're going to tell me I won't do it. You're going to tell me that all that
please, Judge
stuff.
Simpson, please.
Miss Fleming, I've heard it all before. And then the next thing I know, before we even get to your case again, guess what? I'm online reading about your obituary, and I'm not doing it. I'm just not doing it. If they can get the information, I'll take a look at it and I'll potentially reconsider. I'll set a review of her bond on December 22nd, 2005 at 9 o'clock. But at this time, her bond is revoked, defendants remanded.
I'm arrested? Oh my God.
Yeah. Get somebody down.
May I appear for Zoom? Vice for that.
Pardon? Yes. Yeah, I was going to say that.
Thank you.
Yes. That's not a normal.
Phone is, no, it's your phone. Some calling up.
I thought they. Okay. We'll just deal with it. Don't worry about it. I mean, I think they've got to know that Alan's back with someone. Can somebody who doesn't have a case just step out and let court security know?
I got it.
Thank you.
You want somebody to come in here and hear?
Yeah, well, could you let them know that Mr. Allen's in lockup with?
I'll take care of it.
Thank you. Court calls case People versus Frank Hearn Jr.
Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Hearn. Mr. Hearn, say your name for the record.
You gotta unmute first.
You hear me now?
Say again.
Frank Hearn.
Thank you.
Your Honor, I'm requesting an adjournment. Mr. Hearn and I have been playing a little bit going back. I just want to nail down what he wants to do for next steps.
I'll adjourn this to January 21st, 2026, 9 a.m. On continue. Thank you, Mr. Hearn.
You're welcome. January 20.
January 21st, 2026, 9 a.m.
Okay.
All right, thank you.
All right. You welcome.
Court calls the case People versus Shanae Henry.
Conrad Solar on behalf of Pittsfield Township. No comments.
Hello, Your Honor.
No counsel. She has been arraigned. What's your name?
Shanae Henry, Your Honor.
All right, Miss Henry,
Yes.
you don't have an attorney representing you?
No, I need one.
Okay. Would you like to have an attorney represent you on this?
That would be lovely, Your Honor.
Well, usually not called lovely, but okay.
I am lovely, Your Honor.
Whoa, she just took that on herself. Okay.
Of Ms. Henry.
Yes.
So Ms. Henry, if you could do me a huge favor and call the public defender's office to give us your phone number, so that I can be in touch with you at a adjourned pre-trial date, that would be excellent.
Your Honor, does the court have an updated draft?
I do. And so, Ms. Henry, your license is currently valid.
Yes, Your Honor.
Rock on.
So.
Perhaps we can resolve it today.
Yeah,
Well, we can get it
can.
resolved today if that's what you guys want to do. I'm all for it.
Do what?
I said we can get it resolved today. I'm all for it. Just I don't know how this is supposed to really
Well,
work.
I would probably want at least the PD to have an opportunity to discuss it with you, okay? Nothing
sounds
bad's
great,
gonna
Your Honor.
happen. I'm gonna give you another date. Nothing bad's gonna happen to you,
Okay.
okay, regarding that. But that way you can at least have an opportunity to speak with the attorney, figure out what your options are, and do that, okay, ma'am?
Okay. Thank you, Your Honor.
You're welcome. So this is a public defender case, and I'll adjourn this then to January 7th, 2026, 9 a.m., or as your invite indicates. Okay, so call the public defender's office, give them an email and a phone number so that they'll talk to you about what to do next, okay?
Okay. Thank you, Your Honor.
You're welcome, ma'am.
Have a great
All
day.
right?
Mhm.
You do the same.
Thank you. Bye.
Court calls the case, People versus Devin Julia Martinez.
Conrad Solar on behalf of Pittsfield Township.
And Assistant Public Defender Natalie, do you want this? That's finding out.
No, she's not.
Your Honor, I do know she is in warrant status in the first matter.
I don't know, isn't she in this one now? Maybe not.
Yeah, Your Honor. I think this is the first time this has been set.
Since the, okay.
So that being said, I would prosecute it for.
This is a problem. Bench warrant will issue for the defendant's failure to appear. I'm going to set bond at no bond because I believe that's what's set on the earlier case. That warrant will issue immediately. Thank you. Court calls case People versus Erica Mayfield. or Eric Mayfield. Excuse me.
Conrad Siller on behalf of Pittsfield Township.
And Assistant Public Defender Natalie Pate, on behalf of Mr. Mayfield, who hopefully is present on Zoom. He was texting me, I think it was an hour ago at this point, that his phone was at 2%. He was gonna run to his car to get it.
I'm here.
You're there. Okay.
Please state your name, Mr. Mayfield.
Yeah, I got to a charger.
Okay.
That is good. Can you please state your name for the court?
Eric Mayfield.
Okay.
Thank you, Your Honor. I'm requesting an adjournment. Mr. Mayfield, you might have already done so this morning, but we need to get confirmation for this PO, what the consequences may be of a, in this case, so I'm asking for
All right. I'll adjourn it to January 21st, 2026, 9 a.m. I'll forgive Mr. Mayfield out here with camera and letting us know that his battery was low, so I'll do. All right, bond will continue. Thank you, Mr.
Thank you.
Mayfield.
Thank you.
Court calls case People versus Roderick Miller.
Conrad Siller on behalf of Pittsfield Township.
This is a monument, no council contract.
Roderick Miller, will issue an order to show cause. Court calls case People versus Marissa Morton.
Conrad Siller on behalf of Pittsfield Township.
And Assistant Public Defender Natalie Pate, back up Mr. Morton. Who should be on the Zoom.
Yes, there he is.
Can you please state your name for the court?
Marze Morton.
You guys take care.
In the morning.
Yep.
So, Your Honor, I did speak to Mr. Morton regarding this. Frankly, we're asking for a pretty lengthy adjournment if the court would allow. He does have a lot of things he needs to take care of. So if the court would allow possibly 2 months or so, I would ask for.
February 4th, 2026, 9 a.m. Bond continues.
Thanks, Your Honor.
Thank you, sir. Court calls case People versus Michael Nipirla.
Conrad Siller on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Pirla.
Contract.
I did attempt to make contact with him yesterday. I was unsuccessful reaching him.
Bench warrant 5,000, 10%. That warrant will issue immediately. Thank you. Court calls case of the People versus Tierra Peterson.
Conrad Siller on behalf of Pittsfield Township.
Mrs. Public Defender Natalie Pate, on behalf of Ms. Peterson, who I hope.
No,
She has been in.
she'd been in and out. Okay.
I would.
She's not here right now. I'll adjourn it to January 7th, 2026, 9 a.m. Court calls case People versus Charles Roberts.
Conrad Siller on behalf of Pittsfield Township.
This is a show cause, so council not check.
Roberts, no response. Bench warrant will issue. Bond 5,000. I'll give 10% privilege. That warrant will issue immediately. Court calls case People versus Jason Smith.
Conrad Siller on behalf of Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Smith. You know, Mr. Smith has a permit, so he's given me permission to admit to the authorized attack.
So I moved that count to double parking. If you accept that admission, we'll dismiss the original charge.
Ms. Parney, on behalf of your client, do you admit responsibility April 19th, 2025 at the location of Washington Avenue in Pittsfield Township, Washington County, State of Michigan, that he double parked the bus.
I do.
All right, court will accept that admission to count 2. Count 1 is dismissed. Fines and cost of $180. When can that be paid?
I don't have a time frame. I'd ask for a month, 4 weeks.
Make it January 30th, 2026.
Thank you, Your Honor.
Court calls the case People versus Jeremy Wardlaw.
Conrad Siller on behalf of Pittsfield
There he
Township.
is. Jeremy Wardlaw. Thank you.
Thank you, Your Honor. We're requesting an entire court law to get in place.
Adjourn it to January 21st, 2026, 9 a.m. Hopefully.
All right, thank you.
All right, you're welcome, sir. Court calls case People versus Marius Warren.
Conrad Silver on behalf of Eastville Township.
We have Mr. Warren, who's on Zoom. Sir, could you please state your name before?
Marius Warren.
Thank you, Your Honor. I believe Mr. Warren is pretty close to getting his license. When he spoke yesterday, he was going to try to get it to Secretary of State today, or at least schedule an appointment. So I'm asking for,
She's got to schedule an appointment to do.
yes, or at least what we spoke yesterday.
All right,
Try to schedule.
so I'll put this out to January 21st, 2026,
Thank you.
9 a.m. All right, sir?
Thank you, Your Honor.
Thank you. Court calls case People versus Travion Williford.
Conrad Silver on behalf of Eastville Township.
Good afternoon, Assistant Public Defender Laura Perry, on behalf of Mr. Williford.
Yes, I'm here.
State your name.
Trevion Williford.
Thank you.
Your Honor, we are requesting, Mr. Wilford has paid off 2 tickets, each about $500, $600. He says he has one more that's cost $240. He just needs some more time. So especially during the holidays, is trying to work that out.
Oh, okay. What, he wants 5 people present? Is that what it is? He needs the money for the holidays?
I
Yes,
think,
sir.
right?
Is that what it is?
Yes, Your
Really?
Honor. Yes.
You know what? I'm gonna give him the time. He ain't gonna buy nobody anything. No, I'm kidding. All right. Here's what I'm gonna do, young man. If I give you to the 21st of January, would that be enough time for you to
Yes, sir.
do everything? You will?
Yes, sir.
Okay. January 21st, 2026, 9 a.m. All right.
Okay.
Bond will
Thank you.
continue. All right. Get it taken care of.
Yes, sir. We'll do.
All right. Thank you. And I think I have no more files.
I have no more files too.
You got more, Perry?
I don't want to.
Kate?
Punch my head.
Punch in your head. 14A. Stands adjourned. They can remain seated. That's fine. It's been a day. Court does call the case of the People's State of Michigan versus Ryan Joseph Milligan.
Yes, sir.
Good morning, Your Honor. Hannah Mackey requesting permission to practice under Michigan Court Rule 8.120 under Public Defender tortial fees.
Practice is good.
Good morning, Your Honor. Ashley Schultz for People.
Your Honor, we tried to set up a meeting with Mr. Milligan, but Jackson County was not accommodating for Zoom. So it looks like we're going to have to be in person to meet with him. So we're requesting to adjourn this matter.
All right. Mr. Milligan, can you state your name, please, sir?
Ryan Joseph Milligan.
All right. And you heard all of that, sir?
Yes, so you guys are going to have to put me on a writ.
Pardon?
You have to bring me into court.
Well, no, what we're going to do is we're going to adjourn it. Your attorneys are going to meet with you in person. And
Okay.
so then hopefully the next time we get here, we'll be able to have a productive hearing.
Yes, sir. Thank you, Mr. Your Honor.
I like that name. How much time?
3 weeks, Your Honor.
Pardon?
3 weeks. After,
Weeks?
Yeah.
After the holiday? You want the 8th or the 15th?
It doesn't matter.
Probable cause conference will be adjourned to, why don't we do January 15th, just to make sure, 2027, 2026. I don't know where that even came from, 2026, 9 a.m.
Thank you, Your Honor.
Bond will continue.
Mr. Milligan, we'll be in there to see you soon.
All right, thank you.
Thank you, sir. Court does call the case, People versus David Merriquin.
Ashley Schultz for the People.
Assistant Public Defender Jay Bellinger on behalf of Mr. Merrickman, who approaches. Mr. Merrickman, can you please state your name for the record?
David Merrickman.
Go ahead.
In your honor, we are just seeking to waive today. And I did provide an order for release to treatment to the court.
Yes, it doesn't include a couple of things. It doesn't include a GPS tether
Okay,
on this order. So I would order it so I can sign it after the waiver.
certainly.
I need it where it would indicate that there's a GPS tether there, unless there's some objection from the people as to that order.
No, that would be the request of the people as well, Your Honor. Thank you.
I will revise that and send that to the court forthwith.
All right. Your name, sir?
David Merriquin?
All right. You're waiving your right to have a preliminary examination?
Yes.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed, or the offense alleged was committed and that you committed.
Yes.
You understand you'll not have that hearing, see the circuit court for further resolution.
Yes.
People also waive the right
We do, Your Honor.
preliminary examination having been waived, defendants found over the circuit court on a single count.
Your honor, we acknowledge receipt of information, wait formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
January 6th at 1:30 with Judge Cummings.
January 6, 2026, 1:30, Judge County.
All right, thank you very much. I'll get up
You
with
found
the person today
continued.
for you, okay?
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Brandon Dempsey.
Ready, Your Honor, Mr. Dempsey's in the hallway.
Okay, that doesn't help me, but okay,
Because of the no contact and some of the people are in the courtroom. Your Honor.
gotcha.
Assistant prosecuting attorney, I would have to.
Wow, that is red. Between you and Apple, what's this, like a Christmas thing?
No, we're starting a used car lot.
What?
Ken and I are starting our own used car lot.
Okay. All right. Oh, back I have one of those guys that will, anyway.
Good morning, Your Honor. J. Grant Miller, P58658. Please state your name.
Brandon Dempsey?
Thank you. Yes, you may. Six, nine, eight. All right. All right, record should reflect there's been a bench conference in this case. First of all, I'll adjourn the probable cause conference to January 15th, 2026, 9 a.m. Also, and there'll be a order that would be stipulated to that the defendant will be permitted to meet with counsel at a college or university library. But the general provision regarding libraries will remain in effect. But
Yes, Your Honor.
the one exception. So two things would have to occur. It has to be the right kind of library and it has to be for the sole purpose of meeting with counsel.
Yes, Your Honor.
All right. In all other aspects, bond will continue.
And we'll add the other address with the prosecution.
The prosecutor, if there's been a change of address, they can do that straight through community corrections without involving. All right.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Michelle Campbell.
Water Assistant Prosecuting Attorney for People.
Brian Bullock on behalf of Ms. Campbell, Your Honor. Morning.
Good morning, sir.
State your name for the record, please.
Michelle Campbell. Good morning.
Judge, I'm seeking an adjournment. We're still trying to work out a global resolution of all of our matters, so I just asked for an adjourned probable cause
You want
conference.
the 20 or the 30th, or you want the 8th? I think, or the 6th, the 8th.
Eighth would be fine, Judge. Thank you.
Probable cause conference will be adjourned January 8th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Ariana Fenn.
Wow. Ken Water Assistant Prosecuting Attorney for the People. Good morning, Your Honor. J. Grant Miller, P58658 on behalf of Ms. Fenn, who should be on Zoom.
I'm right here.
Okay, state your name, please, ma'am.
Ariana Van.
All right.
Your Honor, I would ask if the court could pass this matter for just a brief bit. I believe Mr. Overwater and I were working on a plea arrangement that'll resolve the matter off the court's docket.
I can prepare a plea.
And that wasn't done.
We were working on it this morning, Your Honor, and ran out of time. I do apologize.
Pass it.
Thank you.
Thank you, Your Honor.
Court calls case People versus Amari Harris.
I'm Bill Wonder, Assistant Prosecuting Attorney for the People.
Morning, Your Honor, with Barnwell, P42-505, on behalf of Mr. Amari Harris.
Your name? Amari Harris. Thank you. What are we doing?
Your Honor, I'm setting it for a preliminary examination. I already have both electronic and paper discovery.
All right, that's on both cases. Ms. Barnwell.
You know
that's
what?
both.
I represent him on the armed robbery.
You're right. It is the public, Ms. White.
I think Mr. Sorrent out there.
And while we await, Barnwell, is there a co-defendant on your case?
Yes, I believe so.
There is, Your Honor. It's Mr. Kilowog's client, Ms. Cruz Menu. Although I believe different counsels coming in on that today.
My understanding, Judge, I might get it from the PD's office, Judge. My understanding we conflicted off of this, off of both matters. So,
I'm sorry?
Both cases involve the same people, Your Honor. If there's a conflict on one, I would suspect there's a conflict in the public.
But I don't have anything that has conflicted them off. Why is that?
You're talking about the armed robbery, that was presented to you.
I know, but
Okay.
you're telling me that this also, there's a conflict.
Yeah, I just earned up that one today.
yes, the file notes say, Judge, that Ms. Barnwell was appointed to both.
Oh.
We have an adjournment so that so that we can make sure you have
We have
all the
that.
paperwork.
I have nothing that says that.
But you have an adjournment and I'll go speak with Ms. Song.
Well, she's asked on the one case, two things here. She's asked on the one case for it to be set for exam. She wants it set for exam, it's fine, but now she's on the other case and I don't know to what extent that dovetails into it. I also have a co-defendant. Mr. Kilowald, is that Mr. Kilowald?
Judge, there's another attorney here who I found out last night is hired. They're going to substitute.
Oh, this is just a bundle of joy. Everybody approach.
Yeah, because people are shaking their head and I don't know what they're shaking their head about.
I bet it.
Can separate from this one.
That's
You
what's
need to put
going on.
appearance on there.
Yes, you're gonna have to put an appearance on the record because I don't have the order.
Okay. Assistant
Good.
Public Defender Sandra White on behalf of Amari Harris.
All right. So the record should reflect we had a bench conference in this case, and just to try to succinctly put it, on the armed robbery case, that being 2162, this Barnwell represents the defendant. Sir, you understand that the public defender is conflicted off of your other case, the weapons case, and that Ms. Barnwell is going to be representing you in that case. Do you understand that, sir?
Yes.
All right. If that isn't enough, there's also a co-defendant, which will be later, and having spoke to all counsel, what we're going to do is we're going to adjourn this matter to December 30th. To allow everything to happen, let counsel for the co-defendant catch up. And then at that point, would be in a position to set these for preliminary. You understand all of that, sir? Yes, sir. All right. So probable cause conference in both of these cases will be adjourned to December 30th, 2026, 25. 9 a.m. And I had given, because certainly Ms. Bardwell was not expecting it, I've given permission that she may Zoom in that day, sir. Okay, so she won't physically be here, but she'll appear via Zoom. You'll be here, but okay. Yes. Okay, very good. Bond will continue. Thank you, folks.
Thank you, Judge.
Court calls case People versus Trenton Raymond.
Morning, Your Honor. J. Grant Miller, P58658, on behalf of Trenton Raymond, who appears via Zoom.
State your name, sir.
Trenton Raymond.
All right, what are you doing?
We'd like to set up for an exam, Your Honor.
Is discovery complete?
Yes.
I'm using the 30th. All right. People have their witnesses available the 30th?
We can try for that day. Thank you, Your Honor.
All right. Preliminary examination in person will be December 30th, 2025 at
9 a.m. with Judge Washington.
9 a.m. with Judge Washington.
Thank you, Your Honor.
Thank you. Bond will continue. Court calls the case People versus Omar Smith.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Good morning, Your Honor. Michael Benson on behalf of Omar Smith.
Oh, there he is. All right. Mr. Smith, can you state your name, please?
Omar Smith.
Okay. You're requesting an adjournment.
Yes, there's an extensive list of discovery still in the
What? I'm sorry.
process. Yes,
How much time are you going to need?
15th of January. Would that be all right? Actually,
If I said no, what would happen?
then I would ask for the 29th.
Does the 15th work? Because I don't trust him. It does? Okay. Press conference will be adjourned January 15th without objection, 2026, 9 a.m. Bond will continue.
Mr. Smith will be in to see you.
Okay, thanks.
Thank you, Mr. Smith.
You're welcome. Thank you.
Court calls case People versus Robert Jameson.
Counsel call this for the people.
J. Grant Miller, P58658. On behalf of Mr. Jameson, who approaches.
Your name, sir?
Robert John Jameson II, sir.
Thank you.
Your Honor, I believe we're just setting for an exam.
The discovery is complete.
I'm sorry, Your Honor?
Discovery complete.
Yes, Your Honor.
People have their witnesses available the 30th.
We'll try for that day. Thank you.
Preliminary examination in person, December 30th, 2025 at 12 noon. That's before me.
Your Honor, my client would like to address his bond conditions.
Go ahead.
Sir, I just want to say that I haven't been in trouble for 3 years. I've been off parole. If there's any way, I currently have $1,000 bond on this incident. If there's any way I could get a personal bond on this, my family can't afford to pay anything, and I certainly will. I will come to court. I've been, like I said, off parole for 3 years, and I'm on the MAT program to stay clean now too. So I certainly think I have a good chance of being clean and staying clean, and I will show up if you allow me to get a personal bond.
Response.
Your Honor, as court continue to bond as currently said, if I understand correctly, the defendant was on parole at the time of this offense?
No.
Oh, I'm mistaken then, but it is assault and
I think
felony.
he said that he was not on parole.
I misunderstood, Your Honor.
And
I
had
apologize.
to, so that we're clear, what I took from it is that he successfully completed parole.
Yes, sir.
And hadn't been in trouble for some period in time. And
And that is the information I have as well, Your Honor.
He previously was sentenced to prison for assault with a dangerous weapon. He was a habitual fourth at that time. And I do understand that he previously had gone to prison in 2014, it looks like, for interviewing with electronic communications and another assault with a dangerous weapon charge. So I would ask the court.
2014.
2014 he went, and then also in 2020, it looks like. So 2 different stints in prison for the same thing that we have here. I'd ask the court find the bond.
Well, when were you then paroled?
I was discharged. Are you talking to me, sir?
Yes.
I was discharged from parole on March 2022, sir. Successfully, I was in Middleton.
I'm
22, sir. Yeah.
22.
Yes, sir. I was discharged from parole.
But
Just over a year, it looks like.
he did just over a year in prison. Was then on parole, successfully completed parole. And from the time he successfully completed parole in 2022, we haven't heard boo from him till now.
Yes, sir.
Is that what I have? I'm going to grant his motion. I'm going to reduce it to a $1,000 personal recognizance bond.
Thank you.
Thank you, sir.
I'm going to tell you something. This exam is before me, and I'll dare you not to come back.
I'll be here, sir.
Because I will be leaving the bench, coming in finding you.
I'll be here.
Hear
sir.
me?
I understand, sir.
Thank you. Court calls case People versus Jordan Bishop Easterling.
Brian Bowling on behalf of Mr. Bishop is Easterling, Judge. State your name for the record.
Jordan Bishop Easterling.
And we have
all the red. No, it's okay. I mean, it's like Maryland, but it's okay. It's just like, it's a lot of red.
We have a resolution. There should be a
Yes,
plea
I do have
before
a
the
plea.
court. And
The plea form indicates he's going to plead guilty to refusing to obey a traffic order to 90-day offense. Upon successful plea to that charge, the fleeing and eluding, which I guess count 1, yes, would then be dismissed. That's the court's full understanding of it.
that's my understanding as well, Judge. Is that your understanding?
Yes.
May I have him sworn?
Right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. State your name, please. Jordan Bishop Easterling.
All right, you can put your hand down. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of refusal to obey a traffic order. That's a misdemeanor punishable by up to 90 days, $100 fine plus court costs. You understand that, sir?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Perry in the 15th District Court. You understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Yes, sir.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of man.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will? Because you believe that you are indeed guilty?
Yes.
On May 24th, 2025, at the location of West Stadium Boulevard near West Liberty in City of Ann Arbor, Washtenaw County, State of Michigan, were you in a motor vehicle?
Yes.
Were you given a traffic order either by hand, voice, sound by a police officer from the Ann Arbor Police Department?
Yes, sir.
That you were being told to pull over?
Yeah.
Is that correct?
Yes.
And you refused to obey that command or order?
Yeah.
All right. Sir, if I accept your plea, I do have to advise you to commit misconduct between the time that I accept your plea and the time of sentencing, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence recommendation or evaluation. Do you understand that?
Yeah, I understand.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
I'm not aware of any, Your Honor.
And have I complied with the court rule?
So is the defense, Judge.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
January 30th at 8:30.
January 30th, 2026, 8:30 before Judge Perry. Bond will continue.
Judge, may I address one issue regarding bond? He's currently wearing
He's out.
I know, he's currently wearing a GPS tether.
He is.
Would the court allow that to be removed based on this plea here today? He showed up for all court dates that I've been with him on.
And I understand that, but also given the underlying nature of the charge, I'm not going to do that at this time. And maybe Judge Perry will feel differently after he's seen by probation.
Fair enough. Thank you, Your Honor.
Thank you. Court does call the case, People versus Jamal Jones.
Overwater Assistant Prosecuting Attorney.
Mr. Alshon.
Pardon? I don't see Mr. That is Mr. Upshaw.
Yeah, Randall Alshon. Yeah. He's not responding.
Oh, there he is. All right, the court has called the case of the People versus Jamal Jones. Counsel, state your appearances.
Overwater Assistant Prosecuting Attorney to the People.
For the record, Your Honor, Randall Upshaw on behalf of Mr. Jones, 43574.
Good morning. All right, what are we doing? In your name, sir?
Jamal Jones.
All right, what are we doing on this case?
We need an exam date, Your Honor.
All right, is all discovery complete?
It's not, Your Honor.
It's not?
It is not. I know he doesn't have, at the very least, the autopsy photos. There is still bullets that are at the lab. There are reports that I just sent over to him today, about 100 pages or so of reports. And I think there's also videos that have to be disclosed. Those are going to go out by the end of the week.
Were you aware of that, Mr. Upshaw?
Your Honor, we've been discussing that discovery for the last, session. It's just odd because my client is incarcerated and he can't go forward without the proper discovery, but it's a shame that he has to be in jail. I think he should have been given a bond, but I don't think he can make it, but I would like to place that on the record.
Okay, so what do you want me to do? Because the way we do this, if you don't have the discovery, we're not going to hear an objection at the time of exam that you don't have that discovery for the purposes of an adjournment. I mean, I hear you and I know you want to move the case forward, but I guess you're getting discovery today and there's other when is all the discovery? The autopsy, has that gotten to counsel or?
The autopsy report has, it's the photographs that they don't have, and that's what they will, I need to do work internally to release those, but that should be done tomorrow.
Well, when did those get, I mean, I guess I'm unclear as to why they don't have all of this now. The last time we were here was what, in October? And I adjourned it out to, well, no, then I adjourned it out to the November date. Is there a, no, okay, and then we were here November 13th. We now have adjourned it out another month and all the discovery's not there. I don't get that.
As it's coming to me, Your Honor, I am sending it on to defense counsel. But the investigation continues. There's still forensic evidence that the Northville lab is working on. The firearms in question then go to Detroit for ballistics evaluation. So the investigation continues.
Mr. Upshur, what do you want me to do? I mean,
well, what normally,
because I get what you're saying and I'm not clear why it hasn't gotten to you. I'm unclear as to that. I don't understand why if the issue is it getting to the people and then getting to you, I have a problem with that it hasn't gotten there because I've been dealing with this since October something at least. And that stuff isn't there. I can understand stuff trickling in a little bit later, but I don't get why some of this stuff hasn't gotten to already. So what would you like me to do, sir? I mean,
Judge, I would like you to, because it's been so long, my client been incarcerated, to dismiss it without prejudice until they are ready to proceed. My client is suffering a great harm being in jail, but I have no other request, Your Honor.
all right. I'm not going to do that. I understand your request, but I'm not going to do that. How long has he been in? When is all of this stuff going to get to Mr. Upshur?
I expect he will have it early next.
No, not expect. When is it going to get to him? Because I want it to him.
Your Honor, in order to release the autopsy photos, I need a memorandum signed by the elected official. I cannot control when he does that. I expect I will get him.
No, that is not an excuse.
I will have it to him tomorrow, Your Honor.
Here's what I'm going to do. I'm going to grant your first request. I get what you're saying. I'm going to set a preliminary examination in this matter. I'm going to set it for December 30th, 2025 at 12 noon. That's before me. I don't know if we will be able to finish it at that point. I don't know how far we're going to get, but at least I can take that and monitor discovery, and I'm not going to penalize the defendant because discovery is not there. We're going to go ahead with the exam. They don't have the evidence, then I'm going to rule if necessary. Bond at this point will continue. Thank you, sir. Court does call the case, People versus Keith Walker.
Andrew Childers, appearing on behalf of people.
Christina Costantino appearing with and on behalf of Mr. Walker, who should be appearing via Zoom. Mr. Walker, can you unmute and state your name for the court?
Keith Walker.
You got it.
Your Honor, may we very briefly approach? Very brief.
Yes.
Thank you.
The plea form indicates that the defendant is going to be pleading to two misdemeanor, both fraudulent withdrawal, 200 to 1,000, the 1 year offenses, 2 counts of that. Upon a successful plea to that charge, those charges, counts 1 and 2 would be dismissed. There is further the agreement that the defendant agrees to pay restitution as ordered. And I would say also, part of the bench conference is that the defendant will keep in contact with his attorney, Ms. Constantino, regarding communications between the prosecutor's office and defense counsel.
That's correct, Judge.
That's all fair. Yeah, thank you.
All right. Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name for the record.
Keith Walker.
All right. Sir, it is this court's understanding that you're going to plead to 2 misdemeanor charges, both of financial transaction device fraudulent withdrawal, 200 to 1,000. Is that
Yes.
correct? And
Yes,
that
sir.
you're pleading no contest, I should say, to those charges. You understand that?
Yes, sir.
All right. Those are misdemeanors punishable by up to 1 year incarceration and a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property, which is the subject of the withdrawal. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, sir.
You understand what a no contest plea is?
Yes.
All right. 2 things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
All right. Now, understanding all of that, do you still wish to plead no contest?
Yes, sir.
All right. Basis for the no contest plea.
Potential civil liability.
All right. Sir, to the charge of fraudulent withdrawal, 200 to 1,000 is contained in count 3. How do you plead?
No contest.
To that same charge as contained in count 4, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
You signed or had cause to have signed an advice of rights form. Is that correct?
Yes.
Do you have any questions regarding any of those rights?
No, sir.
You understand that you're waiving all of those rights, particularly the rights that are contained under paragraph 5, your trial rights.
Yes.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own. You're doing this voluntarily and of your own free will, sir?
Yes, I am.
The court has been provided and has reviewed Washington County Sheriff's Office report for their case number 24-91576. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Sir, I do have to advise you, if between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. Do you understand that, sir?
Yes, sir.
Counsel aware of any other promises, threats, or other inducements that have led to this plea?
No, Your Honor.
All right, and have I complied with the court?
Yes, you have, Judge.
Court will accept the defendant's plea of no contest to counts 3 and 4. Counts 1 and 2 are dismissed. A pre-sentence investigation and report is ordered at 14B. Probation sentencing in this matter will be
January 22nd at 10 a.m.
January 22nd, 2026, 10 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thanks, Your Honor.
Thank you, sir. Court calls the case. People versus Stephanie Cruz Mena.
Prosecuting attorney for the people.
Jessica Kelly, PA 4846, standing in for my law partner, Jeremy Glick, for the purpose of this hearing only on behalf of Stephanie Cruz Mena. Would you please state your name? Stephanie Cruz Mena.
So you said you're appearing for the purposes of this hearing only? Or-
That's correct. My law partner, Jeremy Glick, is.
Oh,
the
I got you.
counsel who
Oh,
is-
Mr. Glick will be, I understand. Okay, gotcha. All right. All right, and this was the co-defendant of the other case, I think, like so long ago. We went to the 30th.
We did. Yes, thank you, Your Honor. We were just retained and need to receive discovery and discuss it with our client. Accordingly, we're waiving the 21-day requirement.
Probable cause conference will be set December 30th, 2025, 9 a.m.
Very good. Your Honor, may I speak to bond?
You may.
Thank you. So we recognize the severity of these allegations, but we've also learned that there are some mitigating factors. Stephanie's a young woman. Now, while she's had some challenges, she does understand her mistakes and that she's facing serious consequences, but she's not a flight risk. She's retained counsel. She's working to address this matter, and she's had an excellent track record of appearing to court before. She is supposed to start school on January 5th. She'll be starting a mechanical engineering program at WCC, and it's important that she stay on track for that.
Mechanical engineering? Okay.
Additionally, she has some excellent friend and family connections in the community, and her parents are supporting her. They've agreed to allow her to stay with them upon her release. So what we're asking for is a reduction in the bond to a personal reconnaissance bond with GPS monitoring, limiting her to school and to her parents' addresses.
Response from the people.
People object, Your Honor. This is an armed robbery. She and her co-defendant appear to have planned this ahead of time. Robbed at gunpoint. The co-defendant had a firearm. Ms. Cruz-Mina had a taser. It's alleged to have tased the victim multiple times in the course of the robbery. There was blood all over the scene. Additionally, at the time of this offense, she was on height of probation for larceny, 20,000 to 50,000 out of Oakland County. People would object.
Anything else?
If a PR bond isn't appropriate, would at least ask that it be lowered. The 500,000 is disproportionate given her lack of flight risk and for the ability to supervise her while not incarcerated, in addition to those previous notes about why we believe.
Well, given the representations regarding the participation or alleged participation in it, I think that the 500,000 will be an appropriate amount. Motion for bond reduction.
I understand, Your Honor. Thank you.
Thank you. Court calls the case of the people versus James Williams.
Assistant prosecuting attorney to the people.
Christina Costantino appearing on behalf of Mr. Williams, who's approaching. Mr. Williams, can you state your name for the court?
Ma'am, James Williams.
Thank you. I know, Judge. I apologize, but can we briefly approach?
Fine.
Sorry. Gotta get my steps.
Yeah, get your steps in.
Born to run. Bench. This is file 252127, People versus Chase Michael Deli. Here with his lawyer, Paul Gibson. Also present is prosecuting attorney assistant Angelique Canfield and their victim advocate staff with the original complainant, Amanda Hunneman. Defendant was charged with domestic violence, second offense. It was reduced. It was reduced to first offense. And the matter was set for sentencing today. We're in the matter of People versus Chase Michael Deli. Some people say Dell. It's Deli, correct, isn't it?
Deli, yes.
File 252127. The case originated on September 5th. The defendant pled on December 9th. There were no contact provisions in place. I lifted some of them, and the matter was set for sentencing here today. So, Mr. Gibson, what would you like me to know?
The defendant indicates that he is employed through a family business, Flores Painting, and he's been there for approximately 3 years. In this situation, the defendant was proactive, you could say. He and his fiance have been going to counseling sessions, and he has obviously had some very stressful and difficult times in his life over the past several years. There's been various incidents that the defendant's been involved with, including being stabbed and having family members and other people pass away in his life. And he's also indicated that he recently reached out to Pivotal because he would like to start individual counseling sessions again that he did in the past. So the defendant, I believe the defendant has, demonstrated that he can be supervised on probation. I don't believe he's a danger to society. I believe that the victim in this case indicated that she doesn't believe that she was a victim of a crime. And so I believe she's asking for leniency. So I would ask the court to consider a probation term or some other type of resolution that does not involve jail time. Thank you.
Ms. Canfield?
Your Honor, I'd like Ms. Honeyman to be able to address the court first.
All right, thank you. Why don't you just have a seat there next to the prosecutor? Good morning. You're Amanda Honeyman?
Yes.
All right. And Mr. Gibson referred to your comments in the victim impact statement where you felt you had not been a victim of a crime. What would you like me to know?
I just would like you to know that in this particular situation, it may be easy to instantly look at him as the aggressor, but it actually was the complete opposite. I was the one screaming.
What were you upset about?
I couldn't tell you.
That's so common. Now, you had an earlier incident in 2024 where
That
he
was
was,
completely different.
all right, he was convicted of domestic assault by a plea. He pled guilty. He did the deferral probation and successfully completed it.
Mm-hmm.
But I'm trying to understand the whole circumstance here. Who is Tina Hart?
She is the tenant in my basement. I have a court date tomorrow over Zoom about her.
All right. I thought who owns the house? Maybe I got it backwards. I thought she was evicting you.
No.
Yes. So you own a house on Coolwater Lane?
Yes.
And she's in your basement. She won't leave. And you're selling the house. You and Chase live at that same house. Now, who owns the house? You do?
I do.
All right. Is Chase on it as well? So you own it alone, and he lives.
He lives there and pays the bill.
All right, but it's in your name,
Yes.
and this lady won't move.
Right.
Where are you moving to?
Union City.
With Chase?
Yes. The house will still be in just my name though.
Okay. Why Union City?
To get out of Poland, So I've lived there for my whole life.
Some people like it in COLA.
Some people.
All right. Well, that's tough when you've got a tenant that chooses not to move. Does that person pay, did they originally pay any rent?
I've seen $500 one time since August, and that's it.
All right, well, we'll deal with that tomorrow in the context of the landlord tenant case. All right, well, Chase did probation and he successfully completed. In fact, I think he's done more than one probation. But he completed the domestic violence, went to the anger management. Let me ask, the more recent incident, was alcohol involved?
Yes.
By both of you? Yes, there's been an alcohol undercurrent to your relationship.
Yeah.
And some of his problems. What is going on in that regard?
We stopped drinking completely, actually pretty recently after that incident, so probably like second week of September. That was kind of the breaking point where, you know, we need to stop. Realization.
All right. And at this point, he's the father of your child. You want to reunite as a family unit and you don't wish a no contact provision.
Correct.
All right. And you're trying to evict your tenant out of the basement.
So
All right. We'll see how that goes tomorrow. All right. Having heard that, Ms. Canfield, what's your position?
Thank you, Your Honor. I've had quite a lot of contact with Ms. Henneman since this case began. One of the reasons that they are engaging in the counseling was at my suggestion as something that they could do to resolve this in a fashion that didn't involve jail and would lead to a better, stronger relationship for both of them, since she did indicate they intended to remain together and get married, and they do have a child together already. I do not seek any jail time at this point. I think a short term of probation with a continuation of the marital counseling they're already engaging in, and then some sessions, as the defendant had indicated he wanted to go to pivotal, could be very helpful to them and find some costs.
Mr. Daly, you and I have spent a lot of time together in the last couple of years. Most of the time you got stabbed and these other incidents. I think Amanda's point that alcohol was interfering with your whole life. So you just stopped drinking?
Yeah, like it's not hard. It, like, can I say about that night was what really started the argument was me saying we're done, and I dumped the beers out, and that's when she got a little upright and a little mean. But like, I haven't drank a drop, and there's no issue with it. Like, I don't really need it. Wasn't a need or a want. It was just something that I did on a daily basis or weekly with dinner. Like, and now it's just drink a lot of water and a lot of soda, which is not as good, you know, but.
All right, I'm gonna do a short probation as the prosecutor requests. I want to make sure you finish your marital counseling and that you do sign up with pivotal. That stabbing incident, there were different versions of what all went down, but you did get stabbed.
Yeah.
And it was because of some bad blood with some other guy, which just a lot of drama in the little village of Colon.
All right,
I'm gonna order 10 days jail credit 1. Of the 10 days, 9 are deferred. You're not gonna do any more jail if you do what I ask you to do. Everything that I assessed as a fine is less money you have for your family. Nonetheless, there's a $75 fine, a $75 crime victims' rights fee, a $50 state minimum fee, and a $240 probation oversight fee. I want you to continue counseling. Sign a release. And follow through on pivotal. No assaultive behavior, no drugs, and no alcohol. Test as directed. We're gonna do a little 6-month timeout. And I want to make sure that there's no alcohol, continues through Christmas and New Year's. You continue with your marital counseling. There is not a no contact provision. You're allowed to live in the same house. I looked at the house on Zillow. It's a very nice home.
Yeah.
The offer seems like looks like a bargain to the purchaser, but I see that you want to get out of it. And
Yeah, it needs some work. There's got some.
does it have lake access?
Yeah, it does.
Well, I know Dr. Melendez's old house,
Okay.
I believe. There's 9 doors that lead outside upstairs.
So it's got a lot of, probably hard to heat it. All right.
Breezy area.
All right. I think you're gonna be okay. I've seen you do well, like with that probation, and I've seen you do not so well. But if we can take alcohol out of the equation, everyone's gonna be better off. Who is doing your marital counseling?
Sue English, I'm not sure how to. pronounce
Out of
her
where?
last name. Life Stance and Portage.
All right, this should go pretty smoothly. All you gotta do, no more criminal activity, no assault or threatening behavior, no alcohol. Continue with the counseling that you're already doing. And you ought to be able to hold that up for 6 months, and then I'll feel more comfortable just taking my hands off the wheel here. So I wish you both luck. I hope I don't see you anymore, at least not in here. Oh, I didn't add up that money. Let's do that.
440 maybe?
No, I think it's 350 plus 240. 590. Could be reduced if the probation is done early. I have a surety bond, so I don't have any money that I can apply to this. In 6 months. All right, you're good to go. Take that down to probation. And I hope things go better. There is a lot of drama in colon. All right, we have a consultation in Ronnie Lee.
All right, record should reflect we've had a bench conference in this case. There is a plea that has been worked out. There are some circumstances. Given those circumstances, I am not going to take that plea today. I'm going to adjourn his probable cause conference to 2026 at 9. What I'm also going to do, Ms. Weidling, is I'm going to order the defendant report over to Community Corrections for placement on a sober link testing device. All right, so I'm going to suggest you do that before you leave this facility, since it's right behind us over there.
Yes,
You
Your Honor.
understand that, young man?
Yes, Your Honor.
All right. think that's everything.
I think that's it,
And
Judge.
all other aspects, bond will continue, and I won't see you before that time. My understanding is your counsel let me know that you're graduating.
I graduated last Sunday, Your Honor.
Oh, you.
Oh, he graduated.
Saying that you
I thought it was this Sunday.
It was on the
My apologies.
The 14th, Your Honor.
graduated on the 14th.
Yes, sir. Yes, Your Honor.
What's your degree in?
A bachelor's in social work.
Oh, because you don't have enough of those. Wow. Young man, congratulations.
Thank you.
Okay, and let's get through this part, okay?
Yes, Your Honor.
Hear me? Okay, thank you.
Thank you, Judge.
No, I know, but you were asking about it.
Court calls the case, People versus Ryan Osborne.
That is on behalf of the people, Your Honor.
Good morning, I'm Rob Tickle. Ryan Osborne, who's approaching the podium. Judge, I know you don't want to hear this, but may we approach very briefly?
Seriously?
Well,
I mean, okay, yes, you may.
I would never do anything unseriously, Judge.
Yes, you. That's funny, Gilmore.
I visited him last night. Mr. Osborne, we had a good conversation. He would like to set this matter for exam. It's my understanding the alleged victim is Miss Self, SELF, is here in court, and she has approached me several times asking if she could have some non-consensual contact. What she would like to do is be able to use one of the monitors here to visit him at jail. Ms. Self, would you just identify yourself?
Yeah.
Is that what you would like to do, have non-consensual contact with him?
All right. Here's what I'm going to do. So discovery is complete.
Yes, Your Honor.
And the people would have their witnesses available the 30th.
We'll do our best.
All right. So I'm going to set preliminary examination in person for December 30th, 2025 at 9 a.m. before Judge Washington. With reference to his bond, I'm not going to change any provisions regarding that. I understand what Ms. Self is requesting. As customary with my practice, I'm not going to change anything. Certainly at the time of exam, Judge Washington can look at it after she hears the testimony in the case. I'm doing that particularly given the nature of the charges that have been filed in this case and then looking at everything. So, and I don't need to hear from her. I'm just not going to change it today. That doesn't mean it won't change on the 30th. And you can address this. Certainly, I'm denying that request without any prejudice. She can bring that up before Judge Washington after the exam.
All right, thank you, Your Honor.
All right, thank you.
Okay, coming back. See you.
Court does call the case of the People versus Susan Brett.
Counsel Water, Assistant Prosecuting Attorney for the People.
Anna Mackey on behalf of Mrs. Bretsick, who's approaching. Please take for the record.
Susan Bretsick, Your Honor.
Thank you. I have a plea form. Is that what we're doing?
It is, Your Honor.
And you don't need to approach?
I do not,
Okay,
unless you
good.
want me to.
All right. Plea form indicates that the defendant is going to be pleading guilty to the charge of unlawful use of a license plate. That is a misdemeanor punishable by up to 90 days and a $100 fine. Upon her successful plea to that count 4, counts 1 through 3 would be dismissed. That's the court's full understanding of it.
That is correct, Your Honor.
That is correct, Your Honor.
May I have her sworn?
Right, and do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole, truth, but the truth so help you God?
I do.
State your name, please.
Susan Brutzik.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of unlawful use of a license plate.
That is correct, Your Honor.
That is a misdemeanor, punishable by up to 90 days in jail, $100 fine plus court costs.
Understood, sir. Yes.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Understood, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty, sir.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Understood, sir.
You signed an advice of rights form, is that correct?
I did.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
That is correct, sir.
You understand you're giving up your right to appeal of right.
That is correct, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily,
I am.
of your own free will,
Yes, sir.
and because you believe that you're guilty of this offense?
Yes, sir.
All right. On the date of February 9th, 2025, I-94 near Huron Street in Ypsilanti Township, Washtenaw County, State of Michigan. Let's see, were you operating a motor vehicle?
I was.
And what was it about the plates on the vehicle?
I was driving without my license and without insurance, and the plate was expired as well, sir.
The plate was expired, and you knew the plate was expired?
I did, sir.
Okay. All right, ma'am, if I accept your plea, in this case, and you commit misconduct between the time I accept your plea and the time of sentencing, that you would not be permitted to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation.
I understand, sir.
And anybody, is there going to be a need she needs to go to probation? Or is anybody going to have an objection if I immediately say, I know Judge
No
Washington,
objection here, Your
I
Honor.
have an objection.
Please, Your Honor.
What?
Please, Your Honor. Please. Yeah, courts are really, they're scary.
Wow, what?
I'd rather have you.
Was this place? Was it scary?
It was seriously intimidating.
Coming in here?
Just walking in court.
It was Alan, right?
Totally Alan.
That intimidated you.
Totally Alan.
Yeah, it wasn't me though.
Not at all, sir.
No?
In fact, I wanted to approach. I told my attorney, I was like, let's just approach because it's so fun.
He'll take you down. You don't want to do that. But you don't know what I'll sentence you to.
Well, that's true. I don't.
And sometimes I just do stuff.
I asked for mercy on the court, sir. Christmas time. It's Christmas time.
Bah humbug. So is anybody going to have any objection to immediate sentencing?
No objection here.
The people do not object.
All right, then I can skip over all that other part. And counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
People are satisfied.
You have, Your Honor.
Court will accept the defendant's plea of guilty to count 4. Counts 1, 2, and 3 are dismissed. Anything either of you want to say before I impose sentence?
No, thank you, Your Honor.
Nothing from us, Your Honor.
Ma'am, anything else you want to tell me before I impose sentence?
You've been very fair, Your Honor. Thank you.
Well, I don't get that a lot either. I like fines and costs of $295, suspend 90 days in jail. When do you think you can get that paid?
The 295,
Yes.
30 days, Your Honor.
In jail? No, I'm kidding.
Um,
That was a judge joke. Don't worry about it. But can you get that paid by January 30th?
I most certainly can, Your Honor.
All right. I'll put that on here, paid by January 30th, 2026. Okay?
Yes, sir.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Court calls the case People versus William Riddle.
And then on behalf of the people, Your Honor.
J. Grant Miller, P 58658, on behalf of Mr. Riddle, who approaches.
Your name, sir?
William Riddle.
All right.
Your Honor, I was hoping to set this for an exam, but I still don't have the correct discovery.
And Your Honor, we did send, I checked the discovery on our end, it is correct. We did send the original link. I don't believe it was ever downloaded, so we resent it again.
Got it. Okay, so you resent it.
I have something that happened much earlier this year that's already been dismissed, so I'll just have to try and re-download the correct link, I guess.
All right. And when are you, that's being sent now?
Okay.
All right. Did you want me to, I'll then grant an adjournment. If you were looking to set it for an exam, it would be set on the 30th. But what I can do to make sure discovery happens, I could just adjourn this out to the 23rd. And then if you guys are ready to go, I just give you an exam date for the 30th. You just have to remind me of that. I won't kick it into the new year.
Please, Your Honor.
Fair enough. Will that work? You understand that, sir?
Yeah, I do.
Okay. Public cause conference then will be adjourned to December 23rd, 2025 at 9. Bond will continue at this time. All right. Thank you. Court calls the case People versus Spencer North. Where's Miss Gaines going?
And then on behalf of the people.
No, you can go, Miss Gaines. I just was wondering where you were going. I was just wondering where you were going because you bring such, as with your name, joy to this room. And I didn't want you to leave because the rest of these folks are going to become a problem. They're behaving because you're here. All right. Thank you. He's refusing.
Edward Driggs on behalf of Norton in 1768.
Assistant Public Defender Hannah Apple, appearing on behalf of Mr. Norton in 1856.
He's refusing to.
Yes, he called yesterday. I believe that he is under the weather, so he had a fever. So that's for an
He's
intern.
under the weather,
Yeah.
which is why he doesn't want to come see us.
If he does have a fever, he can keep that.
Wow.
Your Honor, I did want to put on the record, we did receive his blood alcohol results on case 17, ending in 1768, so I expect there may be additional charges coming.
Got it. Then what I'll do is I'll adjourn this to the 8th, January 8th, 2026, 9 a.m. There are going to be other charges coming and maybe he will then feel better.
Thank you.
Thank you.
Thank you.
Court does call the case of the People versus Eduardo Benavides.
Ashley Feltus for the people.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Benavides, who's approaching, Judge.
Eduardo Benavides.
I have before me a plea form that indicates the defendant would be pleading to the charge of use of a controlled substance, the 1-year offense.
That is correct, Judge.
Yes, Your Honor.
And then count 1 would be dismissed.
Yes, Your Honor.
That's court's full understanding. All right,
There are no other agreements.
we have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Eduardo Benavides.
All right. So it is this court's understanding that you're going to plead to the charge of use of a controlled substance. That's a misdemeanor, punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes, sir.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 district.
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form?
Yes, sir.
Any question regarding those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will,
Yes.
and because you believe that you're guilty of this offense?
Yes, sir.
On June 22nd, 2024, at the location of MacArthur Boulevard near Harris, Superior Township, Washington County, State of Michigan, did you have cocaine in your possession?
No.
Had you used cocaine?
Yes.
So at some point you had it in your possession because you used it, right?
Yes.
All right. And you knew what you were using was cocaine?
Yes.
All right. Sir, if I accept your plea, between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be permitted to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Judge.
And have I complied with the court rule?
People are satisfied.
Offense is satisfied, Judge.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation is ordered at 14A2. Sentencing in this matter will be
January 20th at 10 a.m.
20th,
Yes.
January 20th, 2026, 10 a.m.
Yes.
10 a.m. before Judge Barr. Bond will continue.
May I be heard on bond, Judge?
Sure.
Your Honor, Mr. Benavides has entered a plea today. He was arrested in this matter based on a traffic stop. I don't think he knew, since there was labs, I don't think he even knew the charge was outstanding. He's a long-term resident of the area. He's resided at the same address in Clinton since 2013. He's gainfully employed at a restaurant in Tecumseh at the Big Boy Restaurant. So I don't think he's a flight risk. He doesn't have any holds. He's been in for 55 days as of now. So we'd ask the court to consider a cognizance bond while he's waiting sentencing.
Your Honor, he failed to appear at a probable cause conference in August of this year, and we didn't see him again until the end of October. So I asked him to continue on, concerned about him complying.
My apologies, Your Honor. I didn't know you'd failed to appear.
Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus John Brown.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Sound White on behalf of John Brown.
Your name, sir?
John Brown, how you doing, Your Honor?
I'm doing well, thank you.
Yeah, I'm asking for an adjournment. We have provided some information to Mr. Childers, and I wish to try to continue negotiations with him.
Probable cause conference will be adjourned January 8th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continue. Thank you, sir.
Thank you.
Court calls. Are they coming out with this one or? Sean Gabbers?
Christina Costantino appearing on behalf of Mr. Gabbard.
That's adorable.
John, can you please state your name for the record?
Sean Gabriel.
All right.
And Your Honor, this will be the last time today, but approach. Can we please?
Sure, come on.
Thank you.
I know. I will appear to reflect. Record should reflect we've had a bench conference in this case, and I have signed the green sheet. I will adjourn probable cause in this matter to January 22nd, 2026 at 9 a.m. in Esteban.
Your Honor, the defense is requesting an amendment to bond. We did have a bench conference and we did discuss some of the intricacies of this case and some of the reasons why. But I would point out to the court that my client has absolutely no criminal history of any kind. He is 51 years old, no prior juvenile adjudications, no felonies, misdemeanors, nothing of any kind. He has no history of drugs or substance use involvement. He owns property in Ypsilanti. He has family ties and community ties here. Obviously, we recognize that these are serious charges, but we do believe that there is a lack of likelihood of conviction of this matter. We did indicate at the bench that my client did pass a private polygraph on this issue. He was previously employed prior to his incarceration as a truck driver for the last 30 years. He was working full-time at RNDC Trucking. He has family support, ties to the community, and given that, we would suggest that there is little to no likelihood of risk of flight. We would ask that the court consider a personal bond in this matter, coupled with a GPS tether. My client is in agreement with any and all hotspots or no-go locations that would be deemed appropriate in this case.
I don't need a response, but if people wanted to put anything on the record, that's fine. So what I'm going to do is I'm going to change the defendant's bond to a $500,000 personal recognizance bond. I'm going to have him released. Prior to your release, you'll be placed on a GPS tether location tracking. Sir, do you understand that?
Yes, sir.
And I'm also going to indicate that you are not to enter the city of Milford.
That's correct, sir. Yes.
You understand that?
Yes.
All right. Okay. Thank you.
Thank you, Judge.
Court does call the case People versus Charles Cobb.
Andrew Childers appearing on behalf of people.
Assistant Public Defender Alexis Zerbspithen on behalf of Mr. Cobb. Can you please state your full name for the record?
Charles Cobb. No good name.
Your Honor, we're going to be requesting adjournment. We're waiting on some media discovery.
Oh, you're waiting media. Probable cause conference will be adjourned January 8th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Sir, thank you. Court calls case People versus Jeffrey Bushinger.
Prosecuting on behalf of people, I think that's in.
Stephanie Canna on behalf of Mr. Buchinger.
What's your name?
Jeff Buchinger.
And Your Honor, we are requesting an adjournment of this matter for negotiation purposes.
Okay. You want the 30th or the 8th?
So, I'm sorry, Your Honor.
The 30th or the 8th?
The 8th would probably be better.
All right. Probable cause conference will be adjourned January 8th, 2026, 9 a.m. Bond will continue.
Thank you so much, Your Honor.
Thank you. Court calls case People versus Corey Copeland Nash.
Nash Feltus for the people.
I don't know what that's about. But anyway.
Madam Mackey on behalf of
I'm just gonna
Mrs.
leave it alone.
Copeland Nash, who should be on Zoom, I believe.
Oh, yes. State your name.
Corey Copeland Nash.
Thank you. What are we doing?
Requesting to adjourn this matter, Your Honor. We're almost at a resolution, so the sooner date you have is.
That's correct. I've extended a plea offer, but there are some collateral consequences I think this council needs to discuss.
Sooner date would be the 30th, or I could set it to the 8th.
30th is fine, Your Honor.
30th. Probable cause conference will be adjourned December 30th, 2025. 9 a.m. Bond will continue.
Thank you, Judge. Have a good one.
You do the same.
Thank you. Bye-bye.
Court does call the case of the People versus Tyree Bibbins.
Letters prosecuting attorney to the people.
Suppressed. It is my understanding that defense has filed a motion to suppress, state has filed an opposition. And this entire exchange is captured on video. We're going to submit the video, and then I'm going to decide the motion to suppress on the pleadings. Is that right, Ms. Trainer?
That's fine, Your Honor, yes.
Mr. Engel?
That is correct, Your Honor.
All right. So I'm going to go ahead and decide that issue. And then anything from the state?
Nothing further on that.
All right. We ready for trial?
Yes, sir.
Mr. Engel?
We are ready for trial. As we discussed, my client has raised a couple of issues.
You don't have to get up if you don't want to.
He's raised a couple of issues. I think first he wants to address the court with some concerns he has about the jury selection process. I don't know if you want to say anything.
Yeah, I want to challenge the jury selection and plus about the suppression hearing and so forth.
Okay.
We never had a suppression hearing yet concerning this matter. And I want a full suppression hearing instead of a partial suppression hearing.
Well, when you say a full suppression hearing, Mr. King, the evidence that would be presented at the suppression hearing is all on the video. And essentially, this is a legal issue only as to whether or not you were in custody and that Miranda was required at the time that I think it was the captain, came over to you and said, hey, do you have anything that you want to say? That's a very legal issue. What else would be presented at the motion to suppress other than that?
Coming to the indictment and stuff like that. Coming to the indictment and the statements that they made and so forth. And any evidence that they claim they have.
Okay, I guess I'm still not clear. There is a motion to suppress the statement that you gave based on the fact that you did not receive your Miranda.
Yes.
The evidence for that is the conditions of your confinement, which are already set, and the statement that was made to you that prompted your statements that you made, right?
Yes.
Okay. Because, one of the things, Mr. King, that happens in a trial like this, I've been doing this for almost 20 years now. I have 2 prisons in my jurisdiction. I try a lot of these types of cases. I do understand that the inclination on the part of my defendants is to generally put the entire prison system on trial for every grievance that goes back forever and ever. A trial is confined to what happened on that particular day, what you did, what was done to you, and that is the confines of our trial. Sometimes there are issues that happened in the past. If you have an issue with the other people that were involved in this, that might cast some light onto what happened on that. Every bad thing that you ever did wrong is not necessarily going to come in at the trial. Every bad thing that happened to you while you're at the prison, also not going to come in at the trial, so that we can focus on what happened on that specific day.
Okay, but how about the witnesses that was there present at the time?
Right. I mean, the witnesses, they're going to testify as to what they saw or what happened or what they did on that particular day.
Yes.
Plus we have video, plus you have the right to testify if you want to, but you don't have to. The second issue is your challenge to the jury selection. You have the right to make a challenge to both the way we select the jury, the array, and the way the challenges are conducted. Mr. Engel's already advised me that's probably going to happen during the jury selection. That's fine. I get that.
Okay.
I will work obviously with the state to see which witnesses are subpoenaed, and if there's additional witnesses, obviously, that Mr. King wants brought in, we can see about bringing them in. I will inquire through the court. I assume we don't need to bring in witnesses to authenticate medical records. We can stipulate to their authenticity. And
That's fine. I don't have a problem with that at all.
Okay,
On
regard the
both
doctors
sides,
and
correct,
stuff.
Mr. Engel, for Investigator Hall's records as well.
And can we call the doctors?
I'll talk to you about that separately. My inclination, Your Honor, is to ask about calling the doctors, is that the medical records are sufficient to establish all the facts. Doctors typically just say, this is what is in my medical records. I don't have a real independent memory of anything beyond what's in the medical records. So those usually are the best evidence.
Okay.
On that, but I will, if there's a reason to do that beyond what's in the medical records, we can do that. He also, I know, has inquired about the existence of any other videotapes at the prison, and I had a chance to talk to the state about that. And the state has represented that they have provided all the videotapes in their possession, custody, and control. But I think Mr. King would like them to do a further inquiry just in case.
Yeah, because all the videos, I know all the cameras in the old jail system because of where I worked at. I know it perfectly.
Yeah, I mean, the way that works, Mr. King, is that, the state has to turn over the evidence that they have, and Ms. Trainer has or is making an assertion that you have everything that she has. And if there is video out there that comes to light sometime later, that might be a basis for which you could request a new trial. But I can't assume that Ms. Trainer is not telling the truth to me, that she doesn't have all of the evidence that is out there, just because you say there's more evidence out there when you don't know whether there's another video out there. I get that it's a kind of a catch-22. You have this sense that maybe something's out there that you don't know about. But we can only go on what's been provided by the Department of Rehabilitation and Corrections to the state, to your attorney.
And plus, I would still like to have the videos sent to my private investigator so he can finish his investigation.
I will take care of that.
Okay. All right. So the way we do jury selection, Mr. King, so we're going to be here for our trial. And we will bring you in ahead of time so that you will be seated. I already talked to Mr. Engel about getting some civilian clothing. If you want to be dressed in civilian clothing, you certainly can for the trial. The jury's going to hear and see you in prison outfit on the video anyway, but it doesn't matter to me. If you want to appear here in civilian clothing, make sure that Mr. Engel brings that with him because you're a prison transport. We will change you out here when you get to the courthouse. Based upon the allegations here and your record, I am going to order that you be shackled for the purposes of the trial. So if you notice, your table has a modesty panel that goes all the way around. If you slide up and in, jury's not even ever going to see those restraints on you. We do jury selection. You're going to have jurors both behind you and in the box. We are going to question the jurors. I do an initial voir dire, then I give Ms. Trainer and Mr. Engel each 20 minutes to do their voir dire. Then we do a standard strike and replace, which means that Ms. Trainer is going to exercise a peremptory challenge. Then Mr. Engel is going to exercise a peremptory challenge. Excuse those jurors until everybody has exercised their four or both sides pass. We're going to seat one alternate. There will be a peremptory challenge that is separate from the panel for that alternate. Just for the record, for the purpose of jury selection, Batson challenges only. Mr. Engel, do you want to place Mr. King's race on the record?
Yeah, he is African-American.
Okay. We do have on our jury questionnaire, Mr. King, a spot for race. So Mr. Engel can talk to you about the special accommodations that are made for challenges that are made under what we call a Batson challenge, which is you're a member of a minority class. If we have a juror that is also a member of that minority class, there is a heightened scrutiny to any peremptory challenge that might be made to that juror. Then we're going to have opening statements, and I anticipate that this trial will last no more than 2 days.
Correct.
Okay. If you are going to testify in the case, Mr. King, the way that we would work that is I would take the jury out. You would be placed in the jury box in advance. Then the jury would be brought back in for your testimony. And then the jury will go back out. They're not going to watch you walk up and down from the witness stand in your restraints.
Okay.
Okay. All right. Anything else?
Let me see. Other than the bill in particular and stuff, that's basically it, other than stuff getting to my private investigator.
All right, I understand that there is a bill of particulars. It just hasn't been shared with Mr. King yet.
No, it was shared with Mr.
Oh,
King.
okay.
I never received it.
It was within the discovery packet that I provided to him on August 4th of this year.
And one other question, Your
It's
Honor.
page 70, actually page 71 of the packet I sent to him.
How are we doing transfer of documents, Mr. King? Does it go to tablet, electronic? How does that work these
No,
days?
it comes in.
Hold on, Mr. King, I'm talking to your lawyer. Do we know, Mr. Engel, how that comes?
I do not know.
Okay.
But I do know he did receive that packet.
Okay.
Never received the bill in particular. I received that part, but I never received it.
And if we want, we can print another copy out for him to look at while he's here. I know he's not allowed to take it with him. Right? That's for our transport people. He's not allowed to take any paper into the institution, right?
That is correct.
So he can look at it while he's here.
I'm looking at it now, so.
Oh, okay. All right, good deal. We'll see everybody back here for the trial.
Okay. One last question, Your Honor. Don't mean to disturb you. On this felonious assault, how can I be charged with a felonious assault when he's not a peace officer and there was no weapons involved?
Yeah, I mean, that's a question for your lawyer, Mr. King.
Felonious assault also includes causing unintentional cause serious physical harm. So breaking his eye would be a serious physical harm.
Yeah, but still, he's not a peace officer.
The short answer to that, Mr. King, I'm sure Mr. Engel just told you this, they can charge you with whatever they want. The question is whether or not they are able to establish all of the elements of those charges beyond a reasonable doubt to the jury that's going to be seated at your left.
Oh.
Okay? All right. We'll see everybody for trial. Thank you.
Thank you, Your Honor.
Can you tell me when the trial date is?
Does somebody know when the trial date
January
is?
12th.
January 12th.
Okay, I need to look at this.
We'll see you then.
Is there anyone on this one?
Be happy.
Yeah.
Four cases? Yeah, five. Five. All right. Mr. Curtis, as you know, you're charged with serious offenses involving child pornography. There's a first-degree felony, which carries with it up to life imprisonment in 2459. Then there's a state jail felony, invasive visual recording in 460, which carries with it up to 2 years in the state jail. Then we have another state jail felony of invasive visual recording in 461. And an additional illegal possession of promotion of lewd visual material depicting children, a state jail felony in 2462, and finally in 2463, a second degree felony of burglary of a habitation. So that carries with it up to 20 years in prison. So it's total, you're exposed to 26 years in prison plus life. On all of these, adding them up together. All right, what are we going to do?
Judge, I know we're getting up there in age a little bit.
Yeah,
Miss
yeah,
Wong
year yesterday, I think.
Inherited these cases upon her return to the VA's office. Mr. Davis and I would like some time to speak with her before we formally put these filed up.
You got 4 weeks, and that's it. right?
Yes, sir.
Probably.
Then okay, then we're gonna go to trial, you know, it's gonna be the 2459, the first degree felony.
We know that, that's why
We'll take that
I'm
first.
asking before we get that.
All right, then we'll go one after another, after another. Get a resetting.
Thank you.
Okay. Awa,
He's present.
well, 557. That's another old one. This is another old one.
I know.
So.
Here, sorry.
What are we gonna do?
I suppose the court will put it on the trial docket, if that's necessary. I've got an issue in another county that's unrelated to this. And frankly, doesn't have much bearing on the outcome of this case at all, but
I think there's a deferred offer written down. I don't know what the status of that is, but it's not going to change right now. If you want to just have a little time to work on the other county for a minute. That way we don't have to place it on the trial docket. Just give them 2 weeks.
this case will get resolved without a trial. This might be. I need the other county's issue to have an answer before.
Time wise, what do you ask?
6 weeks.
How much?
6 weeks.
I'm gonna do you 4.
Okay.
Okay, thanks. Armando Alvaro, is that a hearing?
Here, sir.
That's a hearing.
What about Andrew Barnett?
He's present, yeah.
It's not right there in the edge.
So,
Yeah, you're gonna have to unless you won't pin down.
I don't.
Right there. Yeah, it's not.
Trial application.
okay.
We were waiting for me to find the complaint. I found him in Louisiana and he's wanting this prosecuted fully. So it's.
Okay, 3rd degree felony up to 10 years in prison.
Yes, sir.
Right?
Yes, Judge.
I'll give a lot of these.
Yes, sir.
This,
We tried it, actually.
sir.
We've tried several of them.
Okay, then it will be set for trial. And then Alvaro.
This one we already tried jury gave him probation. I think he's asking for removal of something that was on the bond, but it's not on his probation order.
I filed. There's a misdemeanor DWI that was the companion case to the case that we tried in early October.
This is the case out of command.
Yes.
After we received probation from the jury.
Yes, Judge. After that happened, 2 or 3 weeks later, we resolved the misdemeanor DWI for time in the county jail. My belief is that once that judgment was entered, the bond conditions on the misdemeanor are extinguished. So as a condition of his bond on the misdemeanor DWI and at the interlock, he's had it in his truck for 4 years. My position is that the judgment is what should be sufficient to take to Smart Start or any other interlock company to say, I now can have this removed. He's not on probation. It's not a condition of his probation.
Why can't I add it as a condition of probation?
You can, I suppose, as a condition of the felony probation. I obviously would ask the court not to. He's had it for.
Well, okay. What are we talking about now? We're talking about the auto ignition interlock?
Yes. It was a condition of bond in the misdemeanor case.
Okay.
I filed a motion in county court to have it removed because Smart Start? Yes. Smart Start has found insufficient the judgment to take the interlock out of his truck. He is perfectly within the rules to have that removed. It's no longer a condition of his bond. He's not on bond.
Judge, I don't know if we have anything in this court to do with that on the misdemeanor DWI. That may be between the judge there.
Okay, he does.
It declines.
I got an order in August signed ordering him to have an auto ignition interlock system as a condition of community supervision in this case.
On what date, Judge?
On August 27th. Which would be normally customary in something like this. I normally do that. Then that was in August. He hadn't been doing that?
He has been.
Oh, okay.
They're trying to get it removed.
The interlock has been in his truck since December 20.
Okay.
Something of 2021.
Okay. For a different reason.
As a condition
the
of
auto
bond.
ignition interlock is here for this reason, because it's a condition of probation from the jury decision.
Which I overlooked this, otherwise I would have addressed it.
Okay. All right. But I signed, I can't remember actually doing that, but that would be normal and customary. That's what I do in this type of offense.
Wouldn't it be, Your Honor, more normal and customary in a case that's actually a DWI indictment and not? I know this was an alcohol related case. I'm not pretending it wasn't. That's why we tried it. But it was an accident involving injury, not DWI.
It doesn't matter. It was part of the circumstances of the cause of the event.
Understand. Our position, I won't re-argue the bond thing. He's had it for 4 years. He's done well. I know the court and the state's position is probably, he's been in there for 4 years. I get that. But at some point, there must be some level of relief now that the case has been resolved. And I think that the jury's verdict, based on everything that they heard, carries some weight.
Of what? Of what as far as this condition is concerned? Why does it carry weight for my decision on a condition of probation, which involved a circumstance involving alcohol?
I think if the jury believed that those two things were that related, we wouldn't be here. He would have gotten 10 years in prison.
I'm sorry. Well, number one, you bring some jurors up here and testify to that, number one. But number two, when it becomes my supervision, it's my domain, not theirs. But I don't remember them saying that or reflecting that. I remember this situation. But this, whenever there's an involvement of alcohol or drugs, then we do something to prevent someone from doing something a second time involving a 4,000-pound missile. Everybody has to act responsibly. Lives are dependent upon it. So I'm going to stand by right now that order, and it's going to stay that way. And what does it cost you?
Like $200 a month.
I'm sorry, sir?
$200 a month.
Where are you employed? How are you employed?
I was never employed.
Okay. And at the end of the day, this is what I'm going to conclude with, because I think this is what carries the day on this issue. Mr. Alvera, the consequences of this condition to you and the difficulty that you have to deal with it, and it's the inconvenience of it and the cost of it is far less than the family that lost their loved one forever because you fled while they died at the scene. That's what I balance. Can you understand?
Yes, sir.
It's not a close call. You can figure out how to bring them back to life. I'll drop this condition. I'll probably relieve you of this condition sooner than later. But right now, it hadn't been but a few months.
I don't mean to be argumentative, Judge, but
whatever. What was my order?
This
I'm talking about my order on
August.
this.
I understand.
Okay.
Want to be clear that he had it in his truck while the case.
I'm just talking about my order
Understood.
on this probation. Yeah. Okay. What else?
The misdemeanor case was resolved. The court will also recall that it ordered upfront jail time after the jury's verdict.
Was it 180 days? I guess that's what. Stand by.
I think it was 180.
Yeah. Oh,
It was all of it.
Hold on.
College.
And here's the judgment on this. What's the 180 days jail time on that?
It's gonna be a separate. It'll be,
Yeah, copy this. It's not on there, Judge. That's just a interlock. That's yours. That came out of the court's file.
Oh, okay.
That's all I want to make sure it got back for.
Thank you.
that was assessed at sentencing?
Yes.
Have you been going to jail?
Yes.
I know I remember orally ordering that. I'm not seeing it on the written order. Which is more of a memorialization,
Right.
but the court made its order, but it's not in the written order.
But if it's dictated, the dictated order.
No, I mean, I made it.
I know the court told him to go because I told him to go and I wouldn't.
Yeah, I know.
I
I made the statement and it was an order. It was an oral order, but we normally memorialize those for posterity.
Yeah, I'm looking, Judge, I have the order where it shows that he could start weekends.
I think we waited a couple weeks after the verdict to get some affairs in order.
Yeah, I have the order where it said he could start weekend jail time.
Nonetheless, it was ordered, sure, and it's somewhere in the 5,000 case load paperwork that we're having to deal with in this court.
Overstood.
So go ahead. What do you?
I'm asking the court to suspend the remainder of that time. He's done it faithfully.
How many days has he been credited with? Do you know?
It's done.
It's done the 19th.
You're doing every weekend?
Yes, sir.
How many days are you getting credit? Is it 3?
My
You come
PO.
in on Friday?
Yes, sir.
And then they release you on Sunday?
Yes, sir.
You should be getting 3.
Yes.
He's done.
I thought each day Yeah, I thought when he shows up, they give him that credit for that day, and then the second day, and then the third day, even if it's partial, he gets 3 days.
That's correct.
They started it. They only give them 2 now.
Did you know? Kendall?
Yeah, they did stop it, Judge.
Oh, they're just giving it per hour. You have to have 24 hours.
Yes. They're only doing 2 days now. Give them 2 days credit.
All right. Which I don't know how much. Well, do we know how to credit his jail time? We can do that. We can find out where the number is.
Yeah.
Did we find something?
It might be, I reprinted the file, Judge, but didn't have time to go pull it from the vault. So it might be in an order that's not scanned in our file that's in the vault. I just, by the time we got out of court yesterday, I didn't have time to go pull it, so.
Because I've got the community supervision order. I've got
So I reprinted everything that was
the
scanned.
supplemental order signed on the same day of additional terms of probation, which is
It just may be in an order that's not.
auto ignition, complete MRT, moral recognition therapy, and complete defensive driving as directed. But there's no, but I know I orally ordered this there it is, serve a term of 180 days in the county jail. It's in this order.
Okay.
Over the top. But if you can tell me how much credit, and I will say this, this in the timing of such a thing, such a request is not ripe for me at the Christmas holiday season. I'm not gonna stop that condition, since this is the most vulnerable time for people on the roadway. This is where most deaths occur during the holiday season. And
Has he been doing weekends, Paul?
Yes.
and
Because
so I can revisit this at another time, but not now. I'm not going to grant it right now.
They're not showing it?
Well, it doesn't show that he ever booked out.
He's right here.
I know. That's what I'm saying. I'll have to call and tell him.
Following him for escape.
That's why they do it now. They don't do it. They don't book them out until actually the last day. But if you look at the screen that shows the inner something screen, it'll show like the exact days.
Well, does it have a running total? That's what we're looking for. Where's the data that shows a running total?
Well,
What's
What?
his time?
You're showing it's still totaling today, too.
Yeah.
Section.
One more issue, Judge, from what
Question. Because when I go to jailings, it's 91, which is not accurate.
These phones, you turn.
just last month.
But they have broken up in increments.
Okay, so
Is it at the top?
It should be at the very top.
he started in August.
Are you going to jail?
Yes. For September to do right, because August was the judgment.
Same thing we. Sure.
Yeah, what's it called?
See, this would all been important that you're not down.
September, October, December.
But then got what I asked for, more issues. See, my one is so simple.
I don't think I have
Done it
permissions
since
for that.
Okay. So the thing.
That would have been some kind of still have this stuff.
I mean, he can't have 30 to 40 days if he's only doing 2 days.
That's starting. Okay.
He's only credited to 2 days.
I know.
He can only, he's only got 30 or 40 days credit.
Yeah, I don't have permissions for whatever screen breaks it down, Judge. I'll have to if I get permissions for that. So I don't have an accurate.
But during this time, at this time for the circumstances of this case, I'm not granting the relief right now.
Would the court consider modifying his weekend curfew or his ability to operate a motor vehicle on the weekends in lieu of fully suspending jail time? It's about to be crawfish season. He's about to move to working 8 days a week. And the weekend time
Okay,
is valuable.
what is the?
What?
Okay, I have
So that's
be inside your home 10 PM to 6 AM. That's the only curfew.
I'm sorry.
It says be inside your home every day, 10 PM to 6 AM. That's the only curfew. What else is there? What do you, I don't see anything.
Off the way to get some relief. That's
Well,
all I'm
what are you asking for? Because I'm not keeping him in home except during for curfew. I mean, he can
And with
out and about as long as he has an auto ignition.
And with curfew, usually they'll allow you to work if you're working. Isn't it true? Probation allow you to work if you've got a curfew, if you work past that curfew, as long as you let them know.
The reason that I'm asking is because the weekend jail time is going to affect his ability to work. That's why I'm asking for the relief.
Okay, but I'm sorry, but he's going to continue to do weekend jail time for the reasons I stated. It was a fatality in his death. And that may infringe upon his work opportunities, but it's pale in comparison to what happened here and the loss of life. What's the value of that? There is no value to it. It has no quantifiable because it's forever. And the loss of life life is the most precious thing that we have.
Okay.
When we lose it, there isn't anything that is close to value that compares to it. You have your life. You've got some conditions which may be difficult or inconvenient, but you've got a life to share and enjoy with your family and friends. This deceased person doesn't, and their family was lost. And at this time of the year, I'm sure they think, well, that's what people think about. It's their loved ones here and gone. So no, I'm not going to grant the relief at this time for this situation.
We can certainly preserve our right to revisit it later.
Yep.
Okay.
Okay. You may. Yes, sir. All right. Who else was this? Is that it?
Yes.
Okay. That is Andrew Barnett. We put that on the trial. We put that on the
Mike's
trial.
going to dismiss it, but I think it's on the trial now.
Okay. Anything else?
I tried, but my pen broke.
That is all. We're in recess. We have a big doctor tomorrow. Got to get some things done for the last work day.
Yeah.
All right.
Yeah.
Who's approaching?
Alexis Service on behalf of Service Benz on case ending in 0095.
Good afternoon. Good morning, Judge Christopher Quinn, appearing on behalf of Mr. Bibbins.
Any other matter? All right, what are we doing?
Your Honor, in the case ending in 0095, we do have to adjourn because we just got confirmation that there's a conflict in this case and we're going to work on the process to withdraw, Your Honor.
We're requesting the exam. Well, I have the discovery.
Pardon?
I have the discovery. We're requesting the exam.
Let's do the exam case first. And would the people have their witnesses available the 30th?
Oh, December 30th?
Yes.
I'll be out of town. Do I need to contact the court?
And I can do What is the next one, the 6th?
Yeah, I can make the 6th, Judge. Thank you.
Will the people have their witnesses the 6th? You believe? Preliminary examination in that case will be set in person January 6th, 2026, 9 a.m. before
Judge Perry.
Judge Perry. In that matter, bond will continue. In the other case, and it's not related at all to what I just said.
That's my understanding too, Your Honor.
You've identified the conflict.
Correct, Your Honor.
We just don't have counsel yet.
Right, so management signed off on it this morning, so now it has to go to the MAC office to get a new attorney.
All right, so I can get this moving for the defendant. What I'm gonna do is I'm just gonna adjourn this out about 5 days, so that you can come back, know who your attorney is on that one. You hear me, young man?
Yes.
Okay, so I'll adjourn this to December 23rd, 2025, 9 a.m. They'll get the attorney and then we'll see where this case is going. Okay? All right.
Thank you, Your Honor.
Thank you, Judge.
Court does call the case, People versus Earl Covington.
Ron Dowd, Assistant Prosecuting Attorney on behalf of people.
Good morning. Was that you making all that noise getting up here?
I'm sorry.
No, I'm kidding. You're all right. Who's his attorney?
Copy.
Sorry, I didn't hear the case, Your Honor. Simplex Under Doppy Lebo on behalf of Mr. Covington, who stands to my right.
Your name, sir? Earl Covington. Thank you.
And Your Honor, I do need to review some documentation. This case would be requesting adjournment for that purpose.
Probable cause conference, I'll adjourn it to January 8th, 2026, 9 a.m. Bond continues.
Thank you, Your Honor.
All right, thank you, sir. Court calls case People versus Adam Lee Harris.
On behalf of people. Brian Bowling on behalf of Mr. Harris, Your Honor. Adam, can you state your name for the record?
Harris.
Judge, Mr. Harris is prepared to waive his right to a preliminary examination at this time. There is a signed waiver form in the file that I signed on his behalf with his consent.
If that is correct, Your Honor, I understand Mr. Harris already has some cases before Judge Simpson, so hoping to get everything up there.
Up there, get it together. Okay, is that right, sir?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offense is alleged was committed and that you committed it. You understand that?
Yes,
You
sir.
also understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
For the record, people also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on the single count.
Your Honor, I'll acknowledge receipt of the information, waive its formal reading, and stand mute on Mr. Harris's behalf.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial in this matter will be set for
January 5th at 1:30 with Judge Simpson.
January 5th, 2026, 1:30 before Judge Hamoud.
And Your Honor, just for the record, there still is an order for release for possible release for treatment if available in this matter. Is that correct?
Did I sign off on it before? If I signed off on it before, it will continue to.
Thank you, Judge.
All right, thank you. Court does call the case, People versus Carlton Cross.
Assistant Prosecuting Attorney for the people.
Where'd he go? He was just. What?
Hello, Judge Simpson.
Hello, sir.
Assistant Public Defender Doppy Lebo on behalf of Mr. Cross, who stands to my right.
Your name, sir?
Carlton Dion Cross.
All right.
And Your Honor,
Requesting an adjournment.
yes, Your Honor, I have some mitigation information I'd like to present to the prosecution.
Probable cause conference, January 8th, 2026, 9 a.m. Bond will continue. Thank you, sir.
Thanks, sir. Have a good holiday.
You do the same. Thank you. Court calls the cases of the People versus John Hart. Andrew Childers appearing on behalf of the people.
Assistant Public Defender Davi Liebe on behalf of Mr. Hart, who stands to my right. Mr. Hart, could you tell the court your name?
John Joseph Hart.
Thank you. And Your Honor, we're still working on a plea offer in this matter. I would ask for an adjournment.
You think you can get progress toward it by the 30th, or do you need till the 8th?
That would depend on the prosecution's position, but I have no reason to believe we can't make progress by the 30th.
This is the first time I've been made aware that we're even negotiating. Oh, no. How exciting. They must be getting. Are you, is he held on anything else?
He is, Your Honor. Your Honor, he's expecting to be released on the 19th. He's being held on a matter in the 15th District Court where he can be released upon completion of Beyond Barriers, which he's indicating to the.
Got it. So, but when you say the 19th of what?
January, Your Honor.
Okay, so let me do this so that everybody can get what they need to get together. I'll adjourn this out to January 8th, 2026, 9 a.m. on all these cases, so they can have fruitful conversations.
Your Honor, that's why I brought the book to let you know I'm making progress. You know, I am making progress.
I don't doubt that you are. I had faith in you that you would do it when sometimes people have to be sat down.
Yeah, Judge Valvo ordered it, and I'm glad she did. It's a great class.
Great, fantastic. All right, thank you. Court calls the case People versus Juwan Daniels.
Assistant Public Defender Sandra White on behalf of Juwan Daniels.
What's your name, sir?
Juwan Daniels.
I'm asking for an adjournment. At this time, the prosecutor has not extended an offer, so I want to submit some information to try to hopefully get some negotiations started.
See if we can. Probable cause conference in this case, I'll adjourn January 8th, 2026, 9 a.m. Bond will.
Thank you, Your Honor.
Thank you. Thank you, sir. Court calls the case of the People versus Trevor Howard.
Alexander on behalf of people.
Michael Gaddy, on behalf of Mr. Howard, who's approaching judge.
Trevor Howard. Thank you.
Your Honor, we're asking for an exam in this matter.
All right. Discovery is complete.
To the best of my knowledge, Judge.
People have their witnesses available the 30th. Preliminary examination in person, December 30th, 2025 at 12 noon. That's before me.
Thank you, Judge.
Bond will continue. Thank you. Court does call the case People versus Charles Lee Davis II.
People.
Brian Bowling on behalf of Mr. Davis, who should be on Zoom, Judge. Mr. Davis, can you state your name for the record, please?
Charles Davis.
Thank you, sir.
Your Honor, I'm asking that this matter be set for an exam. To my knowledge.
Discovery is complete.
To my knowledge, it is.
People have their witnesses available the 30th.
We can try for that date, Your Honor. Thank you.
Preliminary examination in person, December 30th, 2025, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Bond will continue. Thank you, sir. That is an in-person proceeding. Court does call the case of the People versus Jermaine Johnson. Just tell her no.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Johnson. Mr. Johnson, will you state your name for the record?
Lamont Johnson.
Thank you, sir.
Your Honor, we are asking for an adjournment. We have, I believe, reached an agreement that was proposed this morning, so I'd ask for a brief adjournment so I can discuss that with my client. I did prepare an order for release to treatment. I believe the court, if the.
Yeah, I do have
on
that. And I will sign off on that order. So we can get that out of the way. Probable cause conference, I'll adjourn this to December 30th, 2025, 9 a.m.
Thank you. And Your Honor, I believe that he needs to be arraigned on a amended count two on
Oh,
5805.
Just adding a misdemeanor count over.
which case is that on? I got it. Okay, as to the arraignment on count two, the open and taxing a motor vehicle.
Your Honor, we'll waive reading. My client will stand mute.
All right.
Acknowledge receipt.
And then stood mute to count two, court will enter a not guilty plea. Changing the bond condition. So these matters then are adjourned to December 30th, 2025, 9 a.m. Both matters.
Get to treatment.
Oh, got it. That's on the, consistent with the order.
Yes.
Oh, gotcha.
Yes.
Okay. All right, we're all set. Thank you.
Okay.
All
right.
Court calls case People versus Robert Dolan.
Assistant Public Defender Sandra White on behalf of Robert Dolan. Make his way to the court. Oh, Mr. Allen.
Your name, sir? Robert Dolan. Dolan.
I'm sorry. Yeah, I'm asking for an adjournment in this matter. I do need to see if there's more discovery I need to request from the people, but also negotiations and to review some discovery with Mr. Dolan.
Probable cause conference will be adjourned January 8th, 2026, 9 a.m. Bond continued. Thank you, sir. Court calls case of the People versus Sandra Law.
Ashley Phelps for the people.
Stephanie Andrew, behalf of Ms. Law. Ms. Law, could you please state your name for the record? Sandra Law.
Thank you.
And Your Honor, we are requesting an adjournment. A part of this is she needs to get into treatment so that I can try to negotiate this offer. You did sign an order for treatment. She was actually supposed to be released to treatment this week. Judge Washington changed some of the parameters for the release for treatment. And so.
What's that mean?
Well, the treatment facility she was going to was a shorter term than the one Judge Washington wants her in.
Got it.
And so we're trying to get her into treatment. In the meantime, I did email a request for the offer here. So we're just asking for adjournment so she can get into treatment. She still also wanted me to let you know she still has the concern regarding being evicted. I told her that I would check with the court to make sure there's no evictions in process. The last time I checked, I didn't see one.
Yes. What was her?
What's the name? What's your daughter's name?
I think the court, we were here last week and Ms. Law was concerned about, we couldn't find any current eviction case. The court was found one that had been dismissed.
Yes, that is correct. What is your daughter's name?
It's Sandy Sherman versus Thomas Berry.
Pardon?
Thomas Berry is the landlord.
Berry.
You're looking for anything.
Right.
Serenity Sherman was.
Yes.
So I do have a case being filed on 26 at 8:35.
It does.
Yeah.
Okay. So.
So she is
Okay.
just.
Is that? Can you tell if that's an NPR or?
According to the GA, I asked this information.
Ew. Okay. You don't know what that means. So NPR would be a non-payment of rent case. Termination at some other reason for terminating tenancy, whether it be expiration of the lease, a violation of the condition, something along those lines. That it's not about money. I guess best way to put it.
Okay.
So typically, I'm just gonna time this out. You said that was on the 26th.
Yes, sir.
I'm here on the 2nd.
No, sir.
I'm not. Okay. So here's what I'll do. We won't know anything. Typically in those cases, what happens is the first date is an adjourned date so that they can get counseled or do whatever, or seek assistance, the like. From the 26th, since I'm not available on the 2nd, the next date that that case would be set, as long as somebody shows up and it's not a default, would be the 9th. Okay, so nothing is going to happen until that point. And let's just, so I know it doesn't help your worries necessarily any, but just play that out, that if on the 9th, the worst case scenario that a judgment was entered that day, the earliest that anything could happen would be the 19th of January.
So can we maybe, Judge, I know you gave me the 8th before. Can we look at the 8th to make sure she's in treatment and maybe?
Yeah, that's what I was going to do. I was going to set it for the 8th, but I know she was worried about that. I just wanted to give her an estimate as to what we were looking at. So probable cause conference, January 8th, 2026, 9 a.m.
Thank you, Your Honor.
Is that in her daughter's name, the case?
Yes.
Okay.
Yes, Your Honor.
It's all occupants, so, and I lived there with her. She's only 21 years old.
Right, but the name on the case is her daughter's.
Yeah, it's Miss Sermon.
Got it. Okay. Pardon? Yeah, I get it. Or calls the case of the people versus Grant to see you.
Ashley Phelps with people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Ducia. Your Honor, I have not been able to have any contact with him. My understanding is that he had court yesterday before you, and he failed to appear. There was communication that he was in the hospital. He did not issue a warrant on that matter.
I didn't?
You did not,
Didn't.
Your Honor.
Really?
I'm feeling it.
Really, what is going on?
Christmas spirit.
What? No, couldn't have been that. What happened?
He
Why
had
did they
been
do it?
hospitalized and then gotten out of the hospital and then had gone
They-
back
they
to the
were-
hospital.
Right, so
court-
I did see
court-
that communication.
Yes, the court said to Ms. Tierney to provide the proof, even though we didn't have it yesterday, and that's something I requested. And the court indicated it was likely to adjourn today's hearing as well.
Wow. People pay attention to what I
I
said.
really do.
So all sounds great.
So gee, what date did we put that up? We put that to the 7th, I bet. Yes, we
I
did.
think so.
So
Might
probably,
have been the 20, maybe the 21st, actually.
no, I don't. To see you yesterday, I put that out to the 7th.
I have the 21st.
Really? What was I thinking?
All of those dates sound great for me, Judge.
21st of this month?
No, of January, Your Honor.
Oh, I went, okay, I was gonna say. Wow, yeah. Okay.
That's not how you said it.
Adjourn this out January 22nd.
Thank you, Judge.
Boy, I must have. You know what it was? I'm gonna tell you right now. The only reason that happened is parenting. He did something. Don't know what. Court calls the case, people versus Joseph McCallum.
Water System Prosecuting Attorney for the People.
Ryan Bowling on behalf of Mr. McAuliffe, Your Honor. Please state your name for the record.
Joseph McCullough.
All right. Judge, I'm asking this matter be set for an exam. All discovery is complete to my
You
knowledge.
got all, you got everything. No other witnesses available the 30th? Preliminary examination in person, December 30th, 2025. Time? 12 noon. Before me.
Thank you, Judge.
Bond continued. Thank you. Court calls case People versus Ayana Penn.
Overwater Assistant Prosecutor.
Here.
Wow.
What's your name?
Jake Miller on behalf of Ariana Fenn. There are two Fens, Your Honor. I have Ariana.
This Ariana.
This is Ayana. Ayanna.
I'm right here.
Okay, that was the one I was talking to. Okay, there she is.
Yep, I thought it was the other Miss Fenn, Judge. My
So did
apologies.
they, but.
Your Honor,
Hold
Mike
on a
Getty.
second. One is with a Y.
Yeah,
Ayana.
yes, I have Ayana.
Right. You are Ayana Fenn.
Mm-hmm.
Yes?
Yes.
Said a yes. Okay, thank you.
Yes, Your Honor. Mike Getty from the Public
should have done
Defender's
that to
Office
my
for Miss
kids.
Fenn. Your Honor, there's been an offer made. I believe we are going to accept it. I'd ask the court for a very brief adjournment. We've already forwarded the paperwork to Miss Fenn. We just haven't had a
The
chance to get
30th.
we haven't had a chance to get the advice of rights and plea form back signed.
December 30th, 2025, 9 a.m. Bond continued.
Thank you, Judge. I do have a green sheet for that.
All right, thank you. Court calls case People versus Benjamin Spike.
Andrew Children, right on behalf of people.
And I'm acting on behalf of Mr. Spike, who is to my right.
Hello.
Get your name.
I've been Spike, Your Honor. Thank you.
Your Honor, we'd like to set this matter for preliminary examination and all discovery is complete.
People have their witnesses available the 30th. Preliminary examination in person, December 30th, 2025 at 9 a.m. before Judge Washington.
Thank you.
Bond will continue. Thank you. Court calls case People versus Dallas Fritz.
And on behalf of the people. Assistant Public Defender Chelsea Virgils on behalf of Dallas Fritz. Your Honor, I think I submitted a green sheet. We're asking to adjourn. He is in inpatient treatment at Enlightened Recovery, Michigan and Kalamazoo and has been since October 20th. I think we have skipped to adjourn this case a couple times because of that.
Okay.
That's correct, Your Honor. I have no objection to allow them to finish treatment.
When is treatment?
I don't know.
We don't know. All right. Well, why don't I do this then? Probable cause conference, I will adjourn out to January 15th. We'll just see where he is at that. Well, no, I'm going to put it to 22nd. January 22nd, 2026, 9 a.m. Bond continued. Court calls case of the People versus Michael Stone.
Mr. Stone, who is approaching. Mr. Stone, you are the lectern. Please state your name.
Michael Stone. Thank you, sir. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates that he's going to plead to the stated count 2, looks like. Larceny less than $200 to 93-day offense, and also to an added count 4 of attempted resisting and obstructing an officer, count 4, a 1-year offense. Upon his successful plea to that charge, counts 1 and 3 would then be dismissed. Well, Actually, count one would be dismissed. Count three was not authorized by the magistrate. Swear to is what this indicates. That's the court's full understanding of the agreement.
Your Honor, that is my full understanding of the agreement as well.
Yes, Your Honor.
May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So, yeah.
I do.
State your name, please.
Michael Stone.
Sir, it is this court's understanding that you are going to be pleading to 2 misdemeanor charges. Is that your understanding?
That is my understanding.
He's pleading guilty.
Yes, Your Honor.
First of all, this court's understanding that you're going to be pleading guilty to the charge of larceny less than $200. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased 3 times the value of the property taken. If that's greater than $500, that becomes the maximum fine. You understand that?
Yes, sir.
Also, they should be pleading to an count 4 of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court.
Yes, sir.
Still wish to plead guilty?
I do.
To the charge of larceny less than $200, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing a police officer, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
I believe I did.
Any question regarding any of those rights?
I believe there isn't.
Look at paragraph 5. You'll see a copy of the advice of rights on the podium. You recall it now?
I believe I do.
Uh-huh. Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
I'm on parole.
All right. You understand, were you on parole at the time of this offense?
I was.
All right. You understand that your plea in this case could be a violation of your parole?
I do understand that.
You understand that if it is considered a violation of your parole, you could be sent back to do the remainder of your prison term.
I do understand that.
And understanding that, do you still wish to plead to these charges?
I sure do.
All right. Has anybody promised you anything other than what's been stated on the record here today?
No, they haven't.
Has anybody threatened you or coerced you in any manner?
No, they haven't.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you're guilty of these offenses?
Yes, sir.
On the date of July 28, 2025, at the location of 207 North Hamilton Street, City of Ypsilanti, Washtenaw County, State of Michigan, did you, what'd you do regarding a weed whacker that makes you think that
You took her out permission?
I took it without permission.
From where?
Your Honor, I was on drugs and off my medication. So I don't want to lie to you. I'm not gonna lie to you now. I stole it. So.
Well, that's what I'm asking.
Asking how and all that other, I don't know. All I can tell you is that I didn't have permission to remove it from wherever it was taken from.
Okay.
Did you take
You
it?
don't remember taking it?
Not saying I don't remember taking it. I just, let me restate this.
Okay.
Let me restate this. I was off my medication and I was getting high.
Gotcha.
And I didn't have permission to take it.
No, okay. I got you. But all I'm asking, do you remember the series of events? If you don't, there's another way around this, but I'm just asking, do you remember it or you just?
So if you don't remember, say you don't remember where you took it from.
I don't remember where I took it from exactly, no.
Okay, so you don't remember. Do you remember coming into contact with the police?
I remember the running from them.
That's resisting.
Yeah, I remember.
Did you know why you were running?
Yeah, I was off my meds and I was paranoid when I seen them, so I took off before they got out the car.
That may not be resisting, you're just paranoid. Did you know why they might want?
Well, I was sitting on somebody else's porch, so when they pulled up, I didn't let them have a chance to ask me any questions. You gotta understand, all this is off my meds.
Sir, I hear you.
Okay, okay. I'm just letting you know, so you have an understanding.
Your Honor, I believe what he said is sufficient. He saw the police coming. He knew he was somewhere he shouldn't be, so he took off running before they could talk to him.
Okay, that does that.
Yes,
But
so for the resisting.
And for the theft, it wasn't mine. And I removed it from somebody's yard.
Taking it.
No, I'm not saying I don't remember taking it. I clearly took it.
He
I
doesn't
just-
remember
Where I
where.
took it from. Yeah, I don't remember where I took it from, but I took it.
And Your Honor, if I may, so when you say you don't remember where, if we took you back to that location, you wouldn't be able to say that's the where, but you know that you took it from somebody's property? Is that correct?
Yes. Yes. I wouldn't be able to say,
123 Main Street?
yeah.
How long is the police report?
It's not that long, but it was from a yard, not from a store. If that helps the court.
Yeah.
If this isn't a retail product.
Yeah, I know it happened.
Well, I figured that out. I kind of sorted that out from the complaint, but
Your Honor, when he says he doesn't know where, he's saying he doesn't remember the address. He knows.
he doesn't remember taking it.
But that, Your Honor, I just want you to know, it's just because I was off my meds. I'm not saying that it was because
Sir, listen to me.
Your Honor, can we?
I have to have a sufficient basis upon which to accept your plea. I realize you're trying to tell me everything that you can tell me. And so my only reason for asking the questions is I don't think as to that charge, I have the sufficient basis in which I could determine that what you're telling me that you're guilty of a crime.
Well, I remember that it was outside.
Oh, okay, we got that, but
Would like me to send the police report.
here's what I'm gonna do, sir. I'm gonna have them take you back and we'll bring you out again, but I just wanted to say this to you. Would you like to change your plea to a no contest plea? What will happen at that point is I will review the police report in this case. From that police report, I'll make a determination of whether or not there's a factual basis to justify the offenses that you're pleading to.
Fair enough.
Okay, you have a problem with that?
That's fine.
Okay, so what I would need for you to do, and so the two things I'd have to explain to you, it's the same thing, and that is that it means that you're not wanting or contesting those two charges. You get that?
Yes, sir.
All right. The second thing is that when Judge Barr sentences you, he's going to treat you the same as though you had pled guilty.
Okay.
You understand that?
Yes, sir.
All right. So to the charge of larceny less than $200, how do you now plead?
No contest.
And to the charge of attempted resisting and obstructing, how do you now plead?
No contest.
All right, very good. And so now here's where I'm gonna have to then send you back. I'm gonna have to get the report. I gotta review it. We'll bring you back out and hopefully we can finish this.
For the record, Your Honor, there are two separate reports. So you're gonna get two reports, but they're both pretty short.
Good enough. All right, that's fine.
I'll see you just.
All right.
All right.
Court calls case People versus Marshawn Smith. Pardon? He's in.
That's me.
Okay.
I'm right here, Your Honor.
I got you.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of Mr. Smith.
Yes, he's here. Jefferson. What are we doing?
Your Honor, I am asking for a brief adjournment so that I can talk, so that we can speak with Mr. Smith in some more detail. We were able to talk to him yesterday via phone, but it wasn't.
We need more time here.
I do have a green sheet if I may.
All right. Did you want the 30th or the 8th?
Let's do the 30th, Judge, if it's available, and if I could be heard on bond.
Yes. So probable cause conference will be adjourned December 30th, 2025, 9 a.m. As to bond.
Your Honor, like I said, this is a situation where the police were called for a civil standby. Mr. Smith is here via Zoom. He does have stable housing. We can give the court that address. He's not a flight risk. It is in the area. He's gainfully employed and has been so for the last year and a half at the Toyota facility in Saline. He's got a strong support system. So I don't think he's going to be a flight risk. I think he would appear at all court dates. Moving forward, he would comply with any conditions, as is any conditions that the court would deem fit to assure that there is.
When you tell me it arose out of a civil standby, what do you mean?
The police were there for a civil standby, and I believe that he may have been the one to call them. I believe there was a case pending for us, and he asked for a civil standby, is my understanding from the report.
He asked for a civil standby, goes there, and then new charges for whatever reason arise.
If I may, Your Honor.
I don't think you want to.
Okay, I'm sorry. I'll keep mute.
Yes. Ultimately he did end up being charged in this matter.
Responsive to people.
That's one way to read the report. I would read the police were called because the defendant who had been released from jail was back at the victim's residence. A civil standby would have been maybe a more proper way to do it when deputies made contact with Mr. Smith to call and I could go into his criminal history, which is.
That's fine. If there's I get the picture. Defendant's motion for any type of bond reduction in this case is denied at this time. Bond will continue.
Thank you, Your Honor. And just for make sure, I took December 30th is the date, correct?
December 30th.
Thank you.
9 a.m. All right. Thank you, sir. Court does call the case. People versus Brandon Thomas.
Assistant Public Defender Chelsea Vergils with and on behalf of Brandon Thomas, please state your name.
Brandon Thomas. How you doing?
I'm doing well. Thank you for asking.
Your Honor, we're asking for an adjournment and I am asking to address bond.
Of course you are. How much time did you need for an adjournment? The 30th? Will that work for you?
That's fine, Your Honor, yes.
All right. Probable cause conference will be adjourned December 30th, 2025, 9 a.m.
Your Honor, Mr. Thomas is in custody after a bond violation. Missed tests was the issue. Mr. Thomas was previously living with his parents and his 7-year-old child with special needs. His parents got evicted. It was a very tough time where he and his mother both lost their jobs. I believe that the failure to test was a financial issue. However, he does have a job lined up for when he's released and definitely plans to test if you allow him to. He recently finished a 10-week outpatient program. The whole time he was doing that, he was testing. Every test was negative. He reports he's been sober since the alleged incident in this case. He and his family live in Ypsilanti. I don't believe he's a flight risk and would greatly appreciate another chance to comply with bond.
He lives in Ypsilanti?
I believe so. Is that correct?
Yes, Your Honor.
Well, you were testing for 35th District Court at onsite.
Yes, sir.
He's on probation there.
Right. But our problem that we had is that when he was here the last time is that he had not tested at onsite since early November.
That's correct, Your Honor. I believe there was a period of about a month where he did not test. But again, I believe it was a financial issue and his family and his own finances would be more stable.
I understand what you're telling me on that, but how am I going to get him to test now if that issue hasn't changed, right?
With the financial issue?
Yeah. I'm hearing you saying that he didn't test because of financial issue, and I understand all of that. But now you're telling me that he can test, and I don't.
So, Your Honor, with the financial issue that we had and getting evicted, we just got ourselves into a new home, and my father is the breadwinner, and he's a basketball coach, so he's had a hectic week himself. He had 3 games this week. He just had a game yesterday as well, and me being just myself, it was hard for me to come to him with all the things that he had going on and all the finances that he was paying for me to like a 30-year-old son to be like, Dad, can you keep giving me this money? But moving forward, he said he would help me now that we have our new house and getting things together. So I'd appreciate it if you would let me test if he.
Have you been able to verify any of that?
Yes, sir.
No.
I have not verified that, but my main point is that at the time when he stopped testing, he and his mom had just lost their jobs.
No,
He had a new
I
job
get
lined
what
up.
you're saying. But he's telling, so I get that part of it. I mean, I know I look stupid, but I'm not really. I get that part of it. But now you're telling me he can test, and I was asking, why can he now do it?
Because we're in our.
Just, hold on.
Oh, I'm sorry.
And I heard you. I heard what you said to
I'm
me.
sorry.
I then asked, as he's telling me all of this, have you verified any of what he's telling me regarding the new house? Father, those things.
No, I do not have independent verification of that.
Which they are here right now as well.
What do you mean?
My parents, they're outside.
Outside where?
Getting the car that and all my belongings from the courthouse. So if that was possible, he could.
How do you know? So they're not in the courtroom?
No, sir. He didn't want to see me like this in shackles and chains.
I can get that.
But they're here to support them.
And the new place is in Ypsi?
It's in Canton, Michigan.
Not even sure why I'm doing this, but I'll do it because what you're telling me doesn't make entire sense, but I don't think it's a lie. So I'm going to grant you a personal recognizance $25,000 bond. You're to test 2 times per week at community corrections, nowhere else. All right, up here.
Yes, Your Honor.
I'm not going to hear any excuse. I don't have a ride. I'm not going to hear any excuse. I don't have money. I'm not going to hear any of that. You don't show up for the testing or you don't show up at court, we're coming to get you.
Yes, Your Honor.
Am I clear?
You are clear.
I said it for the 30th.
Up here for testing.
Right today?
Yes.
Okay.
Thank you.
Thank you, Your Honor.
Thank you.
She didn't do anything.
No, I'm kidding. Go, just go. Court calls the case, People versus Ayland Fry. Or, well, not Fry, it's Fy. Right. FYFE.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender for Mr. Fife, who's approaching.
Your name, sir?
Alan Fife.
All right.
Your Honor, I have submitted a green sheet. We're requesting adjournment to do some more investigation.
Do what?
To do some more investigation in this matter.
January 8th, without objection, 2026, 9 a.m. Bond continued.
Thank you. Your Honor.
Court calls case of People versus Terrence Weatherspoon.
Good morning, Your Honor. Assistant Public Defender Alexis Simpson on behalf of Mr. Weatherspoon, who's approaching. Can you please state your name for the record?
Terrence Weatherspoon.
Thank you.
Your Honor, at this time, we're going to ask that this be set for preliminary exam.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available the 30th. Preliminary examination in person, December 30th. 2025, 9, what time? 12 noon before me. Bond will continue.
And Your Honor, as to the bond violation,
Go ahead.
I believe Mr. Weatherspoon is willing to admit to the violation today. I would like to address the court in regards to the violation.
Defendant admits to, go ahead. What do you have as this bond violation?
Positive test, Your Honor.
Do we have a,
Your Honor, I believe he was arraigned on the violation early December. I think he's been in custody since December.
got it.
Yeah.
I see.
He's not seen, Your Honor, since being brought into custody.
All right. So you admit to the violation, sir?
Yeah, I mean, for the THC, I was using this like CBD cream. I didn't know it had THC in it. And I think it was another drop for like cocaine and just like self-medicate. I've been shot 13 times, man. So it's just like it get hard some days, you know. So I did use.
And Your Honor, I think the tests kind of reflect that as well. So it was first a positive THC. He learned that the cream he was using had the THC, so he stopped that use for his pain, had a negative test, but then again, had a positive test. So Your Honor, he is very apologetic for that test. We'd ask that you sentence him to 17 days with credit for 17 days and potentially reinstate his bond. He is okay with any home confinement tether. Obviously with release to do his testing, he's okay with increased testing, Your Honor. I do believe he was participating in an outpatient treatment, so he does have support around him. He has the support of his wife. He has family members he can lean on to help him through the road to recovery, Your Honor. So at this time, that would be our request.
Sends the defendant to 17 days on his violation, 17 days credit, 17 served. I'll indicate that his previous bond may be reinstated with the added provision that defendant is to be placed on a GPS home confinement tether.
And Your Honor, just to confirm what the provisions would be on that home confinement, he can leave for testing. Is he able to leave for any kind of medical appointments? As he indicated, he does.
He can leave for medical.
Okay. Thank you, Your Honor.
That's it.
Thank you.
Thank you, Your Honor.
Court calls case People versus Jesslyn Gray. That's how I pronounce it.
Good morning, Your Honor. Assistant Public Defender Alexis Zerbs with it on behalf of Ms. Gray, who's appearing via Zoom. Can you please state your full name for the record?
Jesslyn Gray.
I got it right. All right. All right, what are we doing?
Your Honor, we're requesting an adjournment. We just need to review the media with Ms. Gray. We have the media, just need to set up some time to go over that.
So, probable cause conference will be adjourned January 8th, 2026, 9 a.m. Bond. Thank you. Thank you, Ms. Gray. Court calls case, People versus Alicia Whitberg.
Assistant Public Defender Sandra White on behalf of Alicia Wittenberg.
Your name, ma'am?
Alicia Wittenberg. Your Honor, there has been an offer extended by the people that we are interested in, but it's contingent on her getting into misdemeanor treatment court.
Got it.
So we need an adjournment to seek that out. And I would like to address bond when ready.
How much time are you gonna need to get that?
I was just asking my colleagues, we think maybe, we're hoping 3 weeks.
Probable cause will be adjourned to January 8th, 2026, 9 AM. Okay, and that's to Bob.
Yes, Your Honor, I know the bond was addressed last week. We'd like to renew that. And a release to treatment order was signed. I believe paperwork was submitted to this court that Ms. Wittenberg does do outpatient, intensive outpatient treatment. Since we are trying to get her released to 15 or 8 misdemeanor treatment court, we're asking that she be released to continue her intensive outpatient treatment.
I'm not gonna do that. I'm gonna leave it bond right where it is. You get me some additional information regarding where she is in reference to that, I'll do it, but I'm not, or I'll at least look at it. But at this point, I'm gonna deny your request for any bond change. Bond will continue. Thank you.
Okay, thank you, Your Honor.
Yeah. Court calls case, People versus Zaria, Griffin Bills.
People. Assistant Public Defender Jay Bellinger on behalf of Ms. Griffin Bills.
Zaria Griffin Bills.
And Your Honor, we are just seeking a 3 to 4 week adjournment for purposes of completing a mitigation, submitting that and getting consideration on an offer.
Probable cause conference, January 15th, 2026, 9 AM.
Okay, this will be on a Thursday. Is that gonna be okay? Okay. All right, thank you, Your Honor.
You need it on a Thursday?
It's on, I believe it's the January.
You said it on Friday? What date's bad for her?
Well,
Your Honor, she's just,
No, I'm kidding.
she's just about to start school, so she just wanted to.
Really?
yes. Well, the new semester starts January 12th. And I was just making sure, Washtenaw Community College.
What are you gonna be when you grow up?
Well, I'm going for health administration, so I want to be able to eventually manage my own home with my aunt on my side, my little sidekick. She's a registered nurse, so.
You got a plan.
Yep.
She does. And I'm sure the prosecution will hear all about it in our mitigation report.
I'm sure they will.
Thank you very much.
So, okay, so we'll do it that way. Thank you, man.
Thank you.
Get that stuff to me. I'll do it. Okay. All right, take care.
Court calls the case, People versus Damian Williamson, 2 cases.
On behalf of the people, Your Honor.
Sorry, Judge. Brian Bowling on behalf of Mr. Williamson. I just needed more notes.
Can you state your name for the record, Mr. Williams?
Damian Williams.
Judge,
Fine.
thanks.
exam. I understand the record should reflect we had a bench conference in this case. You'd like both of these matters set for preliminary exam.
I would, Judge, and well, discovery is complete. With respect to the new unlawful driving away of an automobile, there is some video that I did not exactly have yet. Ms. Senda and I have corrected that issue. It's being sent over. I believe it will be available for the exam. Failing that, I don't know that it'll be all that instructive for purposes of the exam. I did speak to Mr. Williamson about that. He and this court's position basically that there would be no adjournment based on that alone. He indicated to me he understood that, Judge.
And it should be available well before the day. I discovered it yesterday, so it should be in the process of getting over to them.
Over to them. Okay. Then would the people have their witnesses available the 30th?
We'll do our best.
Preliminary examination in person will be set December 30th, 2025,
9 a.m. Judge Washington.
9 a.m. before Judge Washington.
And then, Your Honor, if I may address bond.
You may.
Your Honor, with respect to these two pending matters here today, there is a $5,000 bond. I apologize. Yeah. $5,000 bond on the unlawful driving away an automobile case ending in 21668 and a $10,000 bond on the assault with intent to commit great bodily harm ending in 1720. At this point in time, Your Honor, based on my discussion with Mr. Williamson, I would ask the court to consider amending those to personal bonds. He is 28 years old. He is gainfully employed working at a place called Little Diablo, which is a salsa factory. He also cares for his father, who is suffering from cancer. He indicated to me that if this court was likely to continue any no contact orders, he does have a location where he could live with his grandmother in Romulus, or alternatively with his cousin in the city of Detroit. It's also my understanding that there was another matter that was pending before this court, and that Mr. Williamson has made all court appearances in that case. There's never been a failure to appear, was compliant with bond in that matter. From what I could tell, he has no assault of criminal history of any sort. I only saw traffic matters on his records. The complaining witness is here today. It's my understanding that she was asking for the no contact order to be lifted, but it is my understanding the court intends to continue that pending the preliminary examination. But with that being done, I would ask the court to consider releasing him on personal bonds with a GPS tether if the court felt that was appropriate, or any other conditions, so that he can be out to resolve these cases. Thank you.
Your Honor, I would object at this point. I did see a previous conviction for an attempt RMOD that were resolved under HIDA. I did also see the out of Northville for disorderly, Westland for loitering, and Novi for driving with license suspended. I have concerns given these two cases, the first being the GBH. I had concerns given the facts of the case and the injury codes that I saw that had redness and bruising on the victim's throat, a laceration on her finger, bruise into her shoulder. From that event that occurred while she was pregnant at the time, where the defendant strangled her. I also concerned with the new case, given that it was reported he was driving erratically from Detroit to Ann Arbor with speeds of reported over 110 miles an hour by the victim. And when they returned home, he took her car without her permission, and that led to the unlawful driving charge. So I have concerns, would ask that bond remain as set at this point.
May I add one thing?
Yes.
Just for the record, the complaint in the assault GBH, that incident happened on January 17th of 2025. So we're at about almost a year. It's my understanding that there was no contact order prior to him being arraigned on that matter recently. And that he and the complaining witness had been having contact throughout that time, Judge.
Throughout that period.
Correct.
All right. What I'm going to do with this, since we're actually very close to the exam, I'm not going to change it of the bond. I'm going to deny your request. Let Judge Washington hear the exam. Let her proceed also. And I realize the alleged victim is here, wishes the court to change the contact provisions. As I had indicated to counsel, I am not going to change the contact provisions at this point either. All right.
Thank you, Judge.
Thank you. Court does call the case of the People versus Robert Harris.
Jennifer Water, Assistant Prosecuting Attorney for the People.
But nothing was ever sent.
Take your hands out of your pocket. What's your name, sir? Robert. This is still a PD case, but somebody had indicated there might be a conflict, but I don't have any, so I don't know.
I wasn't contacted about this either.
Pardon?
I wasn't notified either.
Your Honor, Assistant Public Defender Jay Bellinger, on behalf of Mr. Harris, I would ask for a brief adjournment so that I can handle it and I can make sure it's handled properly. If you just give us a couple weeks so we can get that done. Apologies.
Probable
Mr.
cause
Harris.
will be adjourned December 30th, 2025, 9 a.m. As your invite indicates. All right.
Okay.
Bond continued. Thank you.
We'll have an attorney be in touch with you as soon as possible.
Court does call the case People versus Jade Wimberly.
I'm down, Assistant Prosecuting Attorney on behalf of People.
Assistant Public Defender Doug Liebe on behalf of Ms. Wimberly. Ms. Wimberly, could you please tell the court your name?
Hi, I'm Jade Oliveri.
Thank you.
And during requesting adjournment, I did email Mr. Dowd regarding a plea offer in this matter. I believe we're still discussing that, and I would like to address bond.
Probable cause conference will be adjourned December 30th, 2025, 9 a.m. Yes, that's the bond.
Thank you. And with regard to bond, Ms. Wimberly indicates to me that she was previously hospitalized at her prior failure to appear. I've not been able to receive any verification of that. However, Ms. Wimberly does tell me that if she were released, she could stay with her mother in Detroit, and we would have no objection to attracting her home confinement tether to ensure her appearance.
I don't need a response. Motion to bond reduction is denied. Bond will continue. Court does call the case of People versus Dustin Hufford.
Assistant Public Defender Alexis Zerps with on behalf of Mr. Hufford. Can you please state your full name for the record?
Dustin Hufford.
And your children.
Your Honor, we'd be requesting an adjournment so we can begin some plea negotiations.
Probable cause conference will be adjourned January 8th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continue. Thank you, sir. Court calls case People versus Jason Campbell.
Jennifer Water, Assistant Prosecuting Attorney for the People.
Assistant Public Defender Doug Liebe on behalf of Mr. Campbell, who stands to my right. Mr. Campbell, can you tell the court your name, please?
Jason Brett Campbell.
Thank you. Thank you, Your Honor. I do believe that we're going to have a resolution at our next probable cause conference. We'll be trusting an adjournment for that, and I would like to address bond on this.
It's the only thing holding him, or?
Your Honor, he does have an out-of-county hold. It's unclear if they're going to pick him up, but that hold has prevented him from being released to treatment.
That what?
The hold has prevented him from being released to treatment, but it's unclear if they're going to pick him up.
Okay, because did anybody say anything to you about Sacred Heart at all?
No, I called Sacred Heart, sir, and we set everything up, and my hold's prevented me from going to Sacred Heart.
The hold from the other court?
From the other court in Detroit, yes.
Because I've released him, I approved release to Sacred Heart.
Yeah.
This case.
Yes.
So what do you? Go ahead. What are you asking regarding bond?
Thank you. I would ask if he could be released on a tether so that he can either be picked up on the hold and then go to treatment if he's released there, or if he could then.
You got to get the other court. I mean, I've done what I could on this one so that he can go. You got to get the other court to do something, Mr. Lee. Well, I mean, that's why I asked the question, because I remembered signing the paperwork.
Yeah, he did file a writ, Your Honor. Unfortunately, at my understanding, that there hasn't been a response.
Yeah, there hasn't been a response. I filed it 5 weeks ago.
A probable cause conference, I'll only go to, put him on the 30th, 2025 at 9 AM. And I'm gonna deny your request at this point and see where we are on.
Your Honor, can I say something? Your Honor, I mean, I've been in here close to 90 days. My mother just got denied. She just got denied a heart transplant through her insurance company. I just want to be able to see my mom. Please, Your Honor, please. Please.
Send me information that the other court is not responding and I'll consider something else. But at this point, you know, I did what I could to try to get you out, sir. It's not me, it's this other.
No, if I get let out on a personal bond, they come and get me. They want the same thing for me in Detroit is to go to treatment. That's all they want.
Well, then you guys need to get to, what court is it in?
36th District.
Somebody needs to just get through to that.
I'll reach out to them, Your Honor.
And just keep banging on their door because there isn't a reason he should be able to get out. Certainly on my case, he can. But he's got to be able to get out on their case. I don't know what, they have not issued a warrant because he hasn't done anything. Right?
The warrant
They
was
just have
issued.
a hold.
Yeah, it's a hold.
And what my notes indicate, Your Honor, is that the call was made to the court. They indicated they would not be picking him up, but a lien message was received by the jail indicating they would be picking him up.
Well, see, again, that's not me. Somebody's going to need to make a determination. They're not going to pick him up, then we'll do what we got to do. I mean, it won't be an issue. If they're going to pick him up, then we can figure out something here. They can come get him and then deal with him there. But they got to make their call.
Yes, Your Honor. I'll reach out to the 36th District Court.
Thank you. Court does call the case People versus Demarion White.
Please, Honorable Court, David Burgess on behalf of Demarion White is appearing via Zoom from the Juvenile Detention Center. Your Honor.
Yes.
Mr. White, place your name on the record, please.
Demarion White.
Your Honor, I was literally just appointed on this case. I have yet to meet with Mr. White. I'm requesting an adjournment of the probable cause conference for that as well as discovery. And I think there's a green sheet.
Yes, I do have a green sheet. Does he have co-defendants and we set those other places or no?
Andrew?
There are no co-defendants.
Not on this one. All right. So how much time did you need, sir? You did the 30th or the 8th?
The 8th. I'm back in front of you on the 8th.
That's good. Probable cause conference, January 8th, 2026, 9 AM, or as your invite indicates, bond will continue as denied. Thank you.
Thank you.
This is Ms. Burgess. Court calls case People versus Caitlin Davidson.
I'm here.
Morning.
Andrew took his print on behalf of people.
Good morning, Your Honor. May it please this Honorable Court, David Burgess on behalf of Caitlin Davidson, who's appearing via Zoom. Your Honor, it's my understanding she was here earlier. I arrived late, so she was present.
Yes, you were late.
I called, I emailed her.
She told me you were late.
I know.
She was screaming into the Zoom.
That's fair. That's fair.
She was really mad.
Yeah.
All right. Ms. Davidson, can you state your name, please?
Caitlin Davidson.
Thank you. All right.
Your Honor, again, I was just appointed on this case. I'm requesting an adjournment for discovery purposes. And the 8th is
She
fine.
didn't say all of that.
No, I'm just fine, Judge.
You know that was me.
I can see her smiling, Your Honor, so it's a dead giveaway, Judge.
All right. Ma'am, I'm going to adjourn your case out to January 8th, 2026. 9 AM. Yes, ma'am.
I have a court in Wayne County on January 8th at 10 a.m.
So you'd rather go there than to come see me? You're like Mr. Burgess. You guys ought to get along real well.
I know, I just don't know how I'm gonna go about that.
Like,
I don't know what
She can appear on Zoom, but I'll give her, I'll set it for the 15th.
That's fine, Judge.
All right.
Okay, thank you so much.
So that way everybody's not stressed and nobody wants to come see me again.
I'll come see you.
Thank you. January 15th,
Okay, thank you.
2026, 9 a.m. Bond
I'm
continued.
almost positive I see you every week, Judge.
Yes, I know. Sense. Court calls the case People versus Ronald Fleming.
Josh Phelps for the people.
Defender Jay Bellinger on behalf of, but not with Mr. Fleming, Your Honor. He has been for the last several months as we've tried to visit him. And obviously, we need to eventually process this case. However, I just don't know how we're going to be set to do that. I understand that he'll want us set for preliminary examination, but
He wants to?
that's my understanding. The last time we talked to him, we did. I know he's been going through the competency. I know he recently came back as competent. I will be following up with the CFP just so that the court knows what the criminal responsibility. So that's my next step. And I understand that if he comes back and they give him a determination for NGRI, I imagine I could waive him up at that point too, for purposes of petition, et cetera.
And I'm not sure if they'll do that before bind over. Sometimes they do, but it's not a given. So at this point, Your Honor, I do think people are going to be filing a motion to proceed without him. We do need to get the case moving. It is a homicide. It's been about a year and a half now, so it's time. We can just get a short date and I'll have that motion filed and get time for defense to respond. I don't know what there is to respond to really, but I'm happy to give that time so that they can make any record they need to make as well.
So if I set it for the 8th, is that going to give everybody enough time?
I can have it filed by sometime next week and I should give defense hopefully enough time with the holidays.
Certainly.
January 8th, 2020, it's 9 a.m. I'll also, there's going to be a motion.
I will tell the court it'll be that same sort of iPad in the cell motion, for lack of a better term, to sort of give him his advice. So that way, if he does continue to refuse, we can proceed to the preliminary examination.
I'll set it on that date at 3 p.m. for the motion part of it.
Okay, thank you, Your Honor.
And also for a, right.
0108, 3 p.m. Thank you, Your Honor.
Yeah.
Thank you.
Continue.
Please do. I'll handle it.
Is he here?
So. He's in custody.
Oh, that one I.
Yeah, and if you're gonna read them, I'll call for him.
Oh, yeah, well,
It'll be good.
yeah. Oh, court recalls the cases of the People versus Stone.
Judge Phelps for the people.
Stephanie Kim on behalf of Mr. Stone.
So could you please restate your name?
Michael Stone. All right. I think we were at the point, and I've now been handed and reviewed Ypsilanti Police Department reports for their case number 259672 and 259663. There's no objection to the court having reviewed those.
No, Your Honor, thank you for doing that.
No objection at all, Your Honor.
All right. Based upon the court's review of those reports, court does find it's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Mr. Stone, I do have to advise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your pleas and would not be entitled, the court would no longer be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, completely.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
I am aware of none, Your Honor.
And has the court complied with the court rule? Would it be proper to accept this defendant's no contest plea?
You have, Your Honor.
Court will accept the defendant no contest pleas to counts 2 and 4. Count 1 is dismissed. There is actually technically no count 3 because it was not authorized. So count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
January 7th at 10 a.m.
January 7th, 2026, 10 a.m. for Judge Barr.
Your Honor, may I address bond?
You may.
We simply are asking for the court to allow him to be released from treatment. It's my understanding he was in treatment, a warrant was issued, and he was picked up from treatment. He wants to go back to the facility.
So he was in treatment, warrant gets issued, they come to treatment, they get him.
Yes.
I think there was a failure here connected to the warrant that got issued.
Because, yes.
Oh, yeah.
Yeah, so.
Yes, absolutely, 1,000%. He was in a long-term treatment facility, so, yes.
I would allow him to go back to treatment.
Thank you, Your Honor.
So what are you trying to hand out?
Just
You
order.
actually had the order?
Always. What? Yes.
What,
I'm
you
a
haven't done?
professional.
No, you haven't. No, you haven't done.
Thank you.
Professional.
Like, some things just happen. This is like a blind squirrel finding the nut.
Merry Christmas. It's a Christmas miracle, Your Honor.
It is. All right. Bond will continue, but I've signed the order allowing you to go back. Good luck to you, Mr. Snow.
Thanks so much.
Court does recall the case, People versus Ariana Fenn.
Wonders, prosecuting attorney for the people.
J. Grant Miller, P58658 on behalf of Ms. Fenn.
She is no longer here.
Your Honor, at this point, could the court adjourn it to the other date for the other Fenn? I believe we have the forms in. I don't know where she disappeared to. She has been
What
on.
date did we put the other Fenn on?
Yeah, we'll have to look, Your Honor, I don't know.
Is it the 30th or the 8th?
The 30th, Your Honor.
30th.
Probable cause conference, I'll adjourn to December 30th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Miller. And I thought Mr. George was gonna be here. That's set for 9. Autumn is here. Are you Ronnie? What's your name, sir?
My name,
Yeah.
John Gavin.
Oh, all right, Mr. Gavin, you're set for 9:30, and Mr. Fleeman is here. I guess we'll address that matter next. Good morning, Mr. Fleeman.
Morning, Your Honor. How are you?
I always enjoy you and your partner getting pulled into the criminal arena. Mr. Gavin, would you come up and have a seat, please?
She's in the phone.
Oh, okay. You're here on Gavin.
Yes.
He's in custody.
Yes, yes.
Is he here yet?
Yes.
All right. Yes,
We have spoken this morning.
very good. Thank you. Yes, that would be Mr. Gavin's mother.
You just like seeing John and I come here and not know 100% of what we're doing.
Well, you generally do know 100% of what you're doing,
I
but
know.
what John told me is he said, I was afraid of this. He said, I was afraid I would come here and I would like it.
That's anytime we learn some new law, that's exactly what that's exactly what happens.
Speaking of drama in Colon, how's everything? How's everything there?
Pretty good as far as I know,
Well, good.
but I feel like sometimes you know more than I do. Good morning.
Morning.
I'm Judge Middleton. I think we met by Zoom. I don't remember. Were you actually in here?
We met by Zoom, sir.
By Zoom. Well,
Yes.
meeting you in person here today. You're Daniel James Gavin.
Yes, sir.
This gentleman is Mr. Tyrone Fleeman. He is a law partner to your lawyer, Casey Strong. He's been practicing law for 25 years or more. And she's unable to be here, and she has prepared him for the case. I understand he's come and met with you this morning. Is that acceptable to you that Mr. Fleeman appears on your behalf?
Yes, Your Honor.
All right, thank you. Prosecutor, do you have any objection to that?
No, Your Honor.
All right. All right, Mr. Fleeman, what would you like me to know?
Your Honor, only that I think we are in agreement with the recommendation made from the victim impact panel that I know that Mr. Gavin has served the 30+ days at this point, and they're asking for a mental health assessment to ensure proper diagnosis and treatment, intensive outpatient rehab, no recreational drugs with routine mandatory drug screens, mandatory individual therapy, anger management, appropriate punitive damages as deemed by the court. I would hope that would be the 30 days she's already served, and then probation with optional residence at community probation to ensure successful integration back into the community. And I don't know if that's necessarily the best place to go here, but I have spoken with Mr. Gavin about the fact that he needs to find a place to go, that he is not welcome to go back to the house. He has to find another place to go. And also, I forgot to mention that at some point you will need to schedule a civil standby with the police to go get stuff out of the house. You don't want to just go there without police going with you. Okay. And Your Honor, I'd ask that you follow the recommendation.
What recommendation are you referring to?
It's actually something that came from the victim themselves, and it was an email sent to Miss Ackerman, Kendra Ackerman. I don't know who that is.
She's kind of famous around here, but let's see if we can. I'm not.
And I'm reading from an email that went from Linda Gavin to Kendra Ackerman.
I don't believe I have that.
Oh. I guess I thought you would already have that. Would you
Well,
copy?
No, I don't have it, but I'm certainly willing to look at it.
And from what I can tell, Your Honor, it looks like Mrs. Gavin prepared that herself. I don't see any other name on that. I don't know if she had help writing it.
Okay, thank you. Do you have it, Ms. Campfield?
No, Your Honor, which is, I'm just speaking with Ms. Ackerman about it. It typically goes right into our file through scanning and let me see.
So I was not crazy to think that you would
Let
have.
me correct myself. Let's see. I do have it, Your Honor.
Okay.
My apologies, I did receive that. And I would like to also point out that Ms. Gavin is present, would like to address.
Yes, I'm happy to be able to hear from her. This is a dynamic that we have often where there's a domestic assault and the assault is between the child and the parent. I don't know, we may have 20 of these a year. And this is sort of the failure to launch syndrome. The defendant's 27, still living in his home. His contention was his mother told him he was a worthless piece of crap and he just sort of lost it. He indicated he was a chronic marijuana user, but marijuana is lawful for recreational purposes for adults. He's either unemployed or underemployed and really needs to launch himself. So let's hear from Miss Gavin first. I just now saw this. Would you come up and have a seat? You're Linda Gavin,
Yes, Your Honor,
and you're Daniel's mother.
I am.
What would you like me to know?
I have prepared a victim statement that I would like to just read to you.
Yes.
As mentioned, I am the victim of the alleged assault involving the defendant on 11/22. I'm submitting this statement to offer perspective, to illustrate its effect on me and outline what I believe to be appropriate sentencing recommendations. But first, I would also like to say that I was initially not directly contacted by the prosecutor's office, specifically by phone, before the pre-exam conference on 12/9, even though I had reached out to their office on 12/4. On that same day, I also left a voicemail for the victim advocate, which I did receive a return call on Monday, December 8th. I'm highlighting this concern because I want to be certain that my rights were adhered to according to the Crime Victim Rights Act. And therefore, I'm here today to ensure that my voice is heard. The events leading to the incident on that day are relevant because it gives insight into his ongoing mental health challenges and current mental status on that day. At the end of September, he was terminated by his employer. And over the course of the next several
Who was the
weeks,
employer?
Peterson Spring Corporation.
Okay.
Over the course of the next several weeks were episodes of increasing explosive behavior, an episode of indecent exposure, and many episodes when his anger was disproportionate to the situation. He participated in online fights with people on Facebook who found his comments so disturbing that 2 individuals contacted non-emergency dispatch phone number. I was contacted on 10/4 at 12:29 a.m. to answer a call from an officer doing a welfare check. We also learned that during that time, he stole money from us to purchase marijuana. The day of the alleged assault, I was involved in a heated discussion with the defendant regarding ongoing issues of household expectations, pervasive lack of respect, marijuana use, unemployment, and improper use of social media. I was told, among other things, you're a loser, you're worthless, you're a piece of shit. In exasperation, I echoed those words right back to him to hopefully demonstrate a how do you like it moment. And unfortunately, it was at that moment I was struck on the left side of my head with a 24-ounce tumbler. I fell onto the bed, covering my head with both hands, and felt 4 or 5 additional blows with that same tumbler. I got up and attempted to flee, but I was chased into the next room and was pushed or tackled under the end of the couch, where I suffered repeated blows with his fist on my arms and back. I pleaded with him to stop, which he did, but then took my phone and locked himself in the bathroom. I repeatedly knocked on the door, begging for my phone. He questioned as to why I wanted it, which I replied that I needed to contact his dad. I wasn't feeling well and needed help. He finally gave me my phone, and I proceeded upstairs to my bedroom and immediately placed a call to 911. During the call, the defendant entered my bedroom, motioning with his hands to stop and could we work things out. I simply shook my head, to which he began walking toward me. I told him more than once to back up. As he lunged forward, I believe I stated, "Somebody please help me," before he grabbed my phone and fled the house on foot. After my phone was returned, I discovered both the location and the phone were turned off. This has affected both my physical and emotional health. I have a confirmed closed head injury with concussion and persistent symptoms of increased headaches, initial episodes of dizziness and tenderness at the pain at the injury site, large bruises on my left arm, small bruises on my back and posterior right arm, and right hand swelling and bruising. My emotional health has been significantly impacted with increased episodes of anxiety and persistent depression, along with symptoms that may be consistent with PTSD, such as flashbacks and nightmares. As a mother, my heart is devastated. And as a victim, I am pleading with the court to consider all options of rehabilitation for this individual. I am not seeking restitution or compensation. You see, this is his second domestic violence charge. The first charge occurred in 2022 when he assaulted his father. His employment history has been problematic, with a history of explosive outbursts, including 1 or 2 episodes requiring assistance with law enforcement after an altercation with a colleague several years ago. He has an extensive history of ADHD, ODD, learning disabilities with suspected bipolar or schizoaffective disorder, and autism spectrum. No formal testing has been done since elementary school age. He was a previous patient with Pivotal and recently established care. Our family was in process of seeking reassessment when this incident occurred. He has a history of chronic drug use and previous alcohol abuse. And in short, his mental health issues and substance abuse history have significantly affected his everyday life. Given his prior history of domestic violence and the severity of this incident, I would recommend the following: mental health assessment to ensure proper diagnosis and treatment program or regimen, intensive outpatient drug rehab, no recreational drugs with routine mandatory drug screens to ensure compliance, mandated individual therapy, mandated anger management course, appropriate punitive damages as deemed by the court, probation with optional residence at the community probation center. Furthermore, at the time of this incident, the defendant was a resident in our home. I'm requesting direction and proceeding with appropriate eviction measures, given his violent history and the fact that we are also in care of his younger disabled sister. Additionally, his father has significant health issues, including stage 4 kidney failure. All these factors, I believe, are reasonable in supporting our decision that we are no longer able to support the defendant, which includes residing in our home. I share this information with you as to not a point of blame, but to emphasize the seriousness of his issues and our concern for his future. His father and I love our son very much, but we are simply at a loss as to how we can help. So, Your Honor, please help us, help our son, so that he does not hurt someone else in the future. Thank you for your time and consideration.
Thank you. That was very eloquent. The police report indicated that they did call the ambulance service out to the house after you got hit in the head. I don't believe there was any blood. Linda was seen by 3 Rivers ambulance, but did not go to the hospital.
No,
She had several small lacerations on the left side of her head and a bruise on her arm. When did you get diagnosed with a concussion?
November 28th, I was evaluated at 3 Rivers Health. I went there after work because I work for Beacon. And so I was having increased headaches and other concerning symptoms that were consistent with a possible concussion. And so I was evaluated at the ER.
I think if the prosecutor had known these things that you shared now at the time they took the plea, maybe we'd be in a different posture here, but I didn't know it either. But the question still remains, this is a problem with not a simple solution. He didn't wake up one day with all of these problems. I'm sure he had a very difficult time in high school. I'm sure he had a treatment plan, and all through elementary and middle school and high school, people that are on the autism spectrum often struggle getting through high school. There is a phenomenon that occurs, and I wasn't sure whether we're dealing with this or not, when young men in their 20s developed schizophrenia. They're living their lives, they're playing sports, they've got friends, and all of a sudden, schizophrenia touches you on the shoulder. There was a young man here in our county who was president of his class. He was a star athlete, all-state athlete, went to college. Went to Boston University Law School and got a law degree. And just about that time, schizophrenia touched him on the shoulder and his life disassembled. He also assaulted his parents. He did pass the bar examination and was ultimately sort of admitted to the bar after a character and fitness hearing. And then he never was able to practice law. He never was to flourish. He's passed away since. And I've seen it hits men more often than women, at least in my experience. So what you're proposing now makes him homeless with zero support system. You guys have gotten to the end of your rope. He's 27. Has he ever lived independently?
He's 31, sir.
31. Has he ever lived independently?
No, he is not.
And so through all of these things, it came down to this. There was an earlier assaultive incident than this one. And I don't disagree, and I understand why you don't want him back in the house, but some of these things are difficult to put together. They're also very expensive.
Sure.
Your suggestion of Twin County Community Probation Center isn't a bad suggestion. It's a wonderful program. We're lucky to have it. It provides structure and housing, but he's a misdemeanant. And you have to be a felon to be eligible to go into that program. So I don't have the authority to put him in there. I'm a big fan of our Twin County Community Probation Center, have been since it started 45 years ago. Ms. Campfield, her suggestions are all about right on the mark. Do you have anything else you wish to add?
Your Honor, I think that those recommendations to the court are more than appropriate, particularly given the extensive history that she's indicated was the precursor to this incident and the severity of this incident. This is something where it wasn't just fist blows. She was struck with a metal tumbler in the head and is still suffering because of that. Do you know how much credit he has, Your Honor?
26 days.
I'd recommend a 90-day jail sentence with credit for 26, and then follow that with at least a 24-month probation.
Then I only have 3 days worth of leverage left. It's a 93-day misdemeanor.
Oh, that's correct. No. Oh, did he plead to a first or a second?
He pled to a first. No, perhaps you're right.
I think he pled to a second offense, Your Honor.
He did plead to a second offense. All right. That gives me 365 days.
So I would like to see the remainder of that time held over his head for mental health treatment compliance and no new assaultive offenses or behavior during the term of probation or any other violations, in order to take medication as prescribed, to not utilize alcohol or drugs that are illicit, to test upon demand. And I think it's absolutely appropriate that he have individual and group therapy, and that should include a domestic violence intervention treatment.
Well,
that should be completed successfully.
That's a lot to pile on here. That's also expensive. But all right, I haven't heard. So we're going to try to fashion a plan for you, Mr. Gavin. You did accept responsibility for this. You told me that you hit your mother in the head with a tumbler. You actually gave her a concussion. You have a feeling of worthlessness and inadequacy. Your mother and father are frustrated. You're 31 years old. The current plan would be for you to live in your parents' basement for the rest of your life. And that's not that great of a plan. But I can't just dump you out on the front steps of the jail and make you homeless and penniless. I need to put together some sort of a plan, and I'm going to need help. I don't have a magic wand and have an expensive, intensive outpatient drug rehab program. I don't know what your drug is. We don't have extensive outpatient rehab for marijuana use. We have people that have opioid dependencies and methamphetamine, and both are very difficult to deal with. Have you dabbled with methamphetamine?
No, sir. No, Your Honor.
Or opioids?
A little bit, Your Honor, in the past.
What kind?
Xanax, Percocet, sir.
All right, Percocets might qualify. And so they don't have an intensive marijuana treatment protocol. Alcohol is also in there. But we do need a number of things. We do need a mental health assessment to ensure a proper diagnosis and treatment regimen. I think you did the anger management course the first time. That class cost $680. The full domestic violence course. There's a probation oversight fee of $40 a month. There's fines, costs, attorney fees. You don't have any money. You're not unemployable. You've had employment, but because of your mental health situation, it's difficult for you to maintain regular employment. I don't encourage looking for disability at this point. I'd like you to have some sort of a life, friends, associates, things to do. But you've never lived on your own. And you're going to have to start. This is a 1-year misdemeanor, not a 93-day misdemeanor. I didn't give you a chance to say anything. Is there anything you'd like to tell me?
Yes, sir. I just wanted to reinstate the fact that I agree on everything that's been stated about my mental health and receiving treatment. And I also wanted to reflect back on the fact of the housing, that situation. My father has told me that he knows well, we have a friend of the family, sir, and he knows someone who runs like basically a halfway house for people like me to get kind of their life back together. It's private practice. And then also Lauren from Pivotal at the jail, she told me something about free housing.
Well, I contacted Lauren after I talked to you the first time. Lauren is our mental health liaison, and she's doing just a wonderful job. We had some good service, then we had some gaps, and she's doing a great job. So I asked her to meet with you to help me with what we're going to try to do here. So good. She can help me find a treatment program. She may be able to help me find a residential program that'll help you take one step at a time. But I'm not just going to let you out of jail and stand on the front steps with 2 cents in your pocket and no socks. So you're going to be in jail for a while longer, which probably includes Christmas in the St. Joe County Jail. I am gonna order 90 days jail credit 26. I can amend it. That leaves 54 days to serve. I can amend it up or down because I'm putting in a probation for 24 months. The fine is 0. There's a $75 crime victims' rights fee, a $50 state minimum fee, $150 attorney fee, and a $960 probation oversight fee. Now, the clock is ticking here. That's not right. 26 and 54.
64, Judge.
64 days. Thank you. We often have to add things up in landlord tenant. I use a calculator, but 64 days. You get 5 days a month good time. So 90 days is 75 days. So I want enough time to try to figure out some placement options for you. Let's add that money up. $1,235. Payment due in 1 year. No drugs and no alcohol, and test as directed. Now, as I said, it's legal for adults to smoke marijuana in Michigan for any purpose they want. They can't do it in certain places, but they can, just like you can order a cocktail, you can smoke marijuana, except when you're on probation. You can't drink any alcohol and you can't use any marijuana or any other drugs unless they're prescribed by a doctor. Have you ever been on medication for your mental health?
Yes, sir.
What kind of stuff were you taking?
Medication for my depression and anxiety, sir.
All right. When were you last connected to Pivotal?
About a month before I came in.
All right, well, that's positive. Cooperate with Pivotal and follow recommendations. Sign a release. Let's say they find a place for you to go, an inpatient program that helps young men get on their feet. I can amend the probation and let you out of jail sooner than 64 days. But this isn't going to be something that they're going to snap their fingers and they'll have a place to put you. But we're going to look for something like that. Because you need to start somewhere to help you get your feet on the ground. They've got the Twin County Probation Center would be a great place. They give you a place to live. They'd help you find a job. They'd help you find alternative housing, like some of these places you're talking about, to transition from the probation center to one of these shared housing places with a job. Do you have a driver's license?
Yes, Your Honor.
All right. Do you have a car?
Yes, Your Honor. It's not in function right now, but yes, I have a car.
All right. Well, that's a plus. All right. Your mother is seeking intensive outpatient drug rehab. I'm not sure about that. I do agree, no recreational drugs with routine mandatory drug screens. We're probably also going to pursue individual therapy, but we need a mental health assessment to assure proper diagnosis and treatment. That starts right off the top. So let's figure out what services you need and then see if we can find a source for them. But in the meantime, you're going to stay in jail. The probation department's going to come out to the jail and see you or contact you by Zoom. I was hopeful when I talked to you at the time of your plea, you accepted responsibility. You've been very receptive here today. That had to be hard to hear your mother sit there and read that stuff. You want to be a better son, a better son, but you get what you get. You didn't ask to have a spot on the autism spectrum. You didn't ask to have a mental illness, but this developed over your entire adult life. You've been living in your parents' basement since you were 18, and it's developed into this toxic relationship. And it's going to have to start by you living somewhere else. They're still going to be your parents. It's going to be an unhappy Christmas, but at some point, there's going to be some sort of reconciliation, and maybe you can be more successful in your life. I don't know. Anyway, you can go with the court officers. I'll notify the probation department, and we'll stay in contact with Lauren Frank.